Ms. Hofmeyer. Good morning, everybody.
Good morning, Chair.
Thank you. Are we ready this morning?
We are indeed.
Okay, thank you.
Chair, I propose just before we commence with the first witness to just give a sense of where we are in the aviation evidence, because we've been running for about a week and we've got about a week and a bit left.
Yes.
There have been some changes in some of the logistics, so I thought it useful just to take a moment and take stock in relation to the 4 investigation areas, what evidence we've heard and what is still to come. So, Chair, with your leave, I'll commence with the first of those areas. The first area of investigation dealt with the 15 billion capital raising exercise that SAA embarked upon in 2015-2016. We have heard the evidence of 3 witnesses so far in relation to that aspect of investigation. They were Ms. Stimple, Mr. van der Merwe, and Ms. Nancy. We still have the evidence to receive from Mr. Mahlangu. Arrangements have been made and his evidence will be received later this week. That will conclude for this phase of the evidence session the witnesses in relation to that aspect. As I indicated at the opening of the aviation evidence, there is an intention to have a second evidence session later in the year where the final strands of that investigation will be picked up. Chair, the second area of investigation is the Northwest ground handling transactions that we've been looking at over the last few days. We have received the evidence of 4 witnesses in relation to those transactions between the Northwest Department of Transport, South African Express, and then Coroneka, amongst other management companies. The evidence has come from Mr. Ngwenya, Mr. Piri, Ms. Patudi, and Ms. Tlatsana. Chair, there are 2 remaining witnesses in relation to that area of the investigation. The first of those is Ms. Viljoen, who will be giving evidence today, and the second is from another company who received payments of some of the proceeds of those monies that came out of the Northwest government through South African Express and into Coroneka. And that will be completed by the end of this week. The third area of investigation, Chair, is an area that looks at jet fuel procurement between SAA, SA Express on the one hand, and an entity called EML Energy. Chair, that evidence will commence today. It will commence after Ms. Viljoen has concluded her evidence with the evidence of Ms. Loock, who is the Airport's Co-ordinator for South African Express. And that will be followed by the evidence of Mr. Vaughan, who is the head of fuel management at South African Airways. Chair, just a practical matter on our estimation for today's proceedings. It is unlikely that we will get to Mr. Vaughan's evidence. We envisage that the day will be occupied by the evidence of Ms. Viljoen and Ms. Loock. Mr. Vaughan is here. He was summoned. He's in attendance. In the light of the high unlikelihood that we will get to him today, I wondered if we may request that he be excused to return first thing tomorrow for his evidence.
That would be fine. What's your anticipation of what time we might be done with the other witnesses, Ms. Viljoen and Mr. Loock?
Chair, we will be able to give you a better sense in the lunch break, if you don't mind. It really does depend how long Ms. Viljoen takes.
Yes.
Ms. September will be presenting the evidence of Ms. Loock. She's indicated to me previously that she thinks she'll need about 3 to 4 hours. So it does depend on how swiftly we finish Ms. Viljoen.
Yes.
But the hope would be to finish Ms. Loock today, whatever.
Yes,
But we will give you a sense, if we may, at lunchtime about how much, if at all past 4, we think we might need to sit.
Okay, no, that's fine. If need be, we can sit beyond 4 o'clock.
Thank you, Chair. We're indebted.
So that we try and finalize their evidence.
Excellent.
Okay.
So Mr. Vaughan can be excused until tomorrow, if you may.
Yes. Mr. Vaughan, where is he? Okay. You are excused from attendance today. Please come back tomorrow and be here at 9 o'clock so that in case we decide to start at 9, you are available. Thank you very much.
Thank you, Chair. Chair, just to complete that third area of investigation, Mr. Vaughan will give us, after Ms. Loock's evidence, the overview of the jet fuel procurement space, and that will become an important lead into the aspect of the evidence that deals with the IDC. I'd highlighted in the opening that there's an aspect of this procurement that involves the IDC because it was off the back of contracts that were obtained or were anticipated to be obtained from SAA and SA Express that a funding application was made to the IDC. So there will also be further evidence in that regard. And then finally, Chair, the fourth area of investigation dealt with broad themes of governance. And that investigation has focused, and the evidence will show, the extent of board interference in procurement matters at South African Airways over a period of time which involved, according to the evidence that will be heard, numerous demands made for the allocations of contracts to certain entities, and also evidence from witnesses who endeavoured to stand up to what they regarded as unlawful demands and then were summarily suspended. Chair, that evidence will commence on Wednesday, and it will run until Monday of next week, with an interlude on Thursday to go back to some of the remaining witnesses. But that, Chair, with your leave, is our plan for the remainder of the aviation evidence.
No, that's in order.
Chair, then without further ado, if we could swear Ms. Viljoen in.
Yes, please administer the oath of affirmation.
Please state your full names for the record.
Calandra Viljoen.
Do you have any objections to taking the prescribed oath?
I don't.
Do you consider the oath to be binding on your conscience?
I do.
Do you solemnly swear that all the evidence that you will give will be the truth, the whole truth, and nothing but the truth? If so, please raise your right hand and say, "So help me God."
So help me God.
Thank you. You may proceed.
Thank you, Chair. Chair, we have Chair, we already entered Ms. Viljoen's bundle into the record as Exhibit DD9. We did that in the course of the evidence of Ms. Tlatsana on the weekend, so there won't be a need to do so again.
Okay.
But Ms. Viljoen, just to orientate you, in front of you, you have a sort of soft cover file, which is comprises your various affidavits and statements. It will be referred to in the course of today as Exhibit DD9. That's necessary just for the purposes of the record. And then you also have next to you a legislation bundle. Chair, we've prepared a legislation bundle that may become relevant in the course of today's evidence. If I may beg leave to hand one up to you.
Yes.
Ms. Viljoen already has her copy there. And then there is just also next to Ms. Viljoen the bundle of Mr. Ngwenya's evidence. There may be a point at which it's relevant to go there. And that is Exhibit DD5.
Okay, thank you.
Ms. Viljoen, if I may then just commence with some assistance in navigating your bundle, because there are a number of affidavits that are to be found in the bundle that has been put together for your evidence. And I'd like to just get clarity in relation to some of them, when they were deposed to, and also to ask you whether there are any corrections you'd like to make in advance of your evidence to any of them. So let's start with the first that appears at page 1. That is an affidavit, as I have it, that you provided to the Commission. And if you go to the end of the affidavit, you'll see at page 16, it was deposed to on the 23rd of May 2019. Is that correct?
Yes.
And are there any corrections you want to make to that affidavit?
No.
The second affidavit, which is actually an annexure to that affidavit which you provided to the Commission, is an affidavit that you did to the then FSB. If you go to page 40 of the bundle in front of you, you will find it's entitled Response to Summons issued under case number 2018/02/6680. But it is an affidavit, as I have it, that you deposed to before a Commissioner of Oaths on the 26th of February 2018. You'll pick that up at page 46. Is that correct?
Yes.
And are there any corrections you'd like to make in that affidavit?
No, Chair.
Thank you. And then the final affidavit, I'm calling it an affidavit with hesitation because the document, which is the affidavit, does not appear to have been deposed to before a commissioner, albeit that it was signed. You'll find that at page 91 of that bundle. Do you have that?
I do, Chair.
And you'll see there it's an affidavit related to the Mafeking case number 4908 of 2017. And if we go in that, I'm going to call it an affidavit, to page 93, can you confirm that that is your signature on that page?
Yes, Chair.
And the date at the bottom is given but without a year. It's 14 December. From my reading of this affidavit and placing it in context, I take it to have been signed on the 14th of December 2017. Is that correct?
Yes, Chair.
And again, are there any corrections you'd like to make to that?
No, Chair.
Thank you. You've confirmed the contents of this affidavit, therefore, under oath, albeit that this was not commissioned at the time. So just for the ease of reference in the course of the proceedings, I'll refer to it also as an affidavit.
Okay, Chair.
I'm sorry. I think you asked her if she confirms.
Yes.
And I saw she nodded, but
Oh,
I'm
yes.
not sure that she confirmed. Sure.
Indeed.
So you'll have to please just articulate your confirmation so that the mic can.
I will do that, Chair.
So just for the record's purposes, you confirm that the contents of the affidavit that appears at page 91 of the bundle contains statements that are true and correct to the best of your knowledge.
Can I add details to this? Because I didn't write this affidavit or this statement.
Certainly.
Someone wrote it for me. Mr. Jan Judil wrote that, and he asked me to sign it.
Right. Let's get a few of those details because they may well be important.
Okay. Sorry, my bundle has now fallen apart.
Okay, maybe let's do this. Let's do it this way. The affidavit as it stands, I think you have confirmed that it is correct. Is that right?
Yes, Chair.
But what you have just said suggests that you feel that there may be other facts that need
Which
to
is
be
covered
added,
in my second.
which are not there.
Yes, Chair.
Okay, no, that's fine then.
Thank you, Chair. I'm indebted to you. So there may be more background you'd like to give, and we'll find that in the other affidavits, but its contents are correct.
Yes, Chair.
Thank you. Chair, I do note that Ms. Viljoen is struggling with
Yes.
the manner in which the file has been put together. I've asked my learned friend, Ms. Buthelezi, if she wouldn't maybe just take a spare copy of that file that we have and place it in a file,
Yes.
which then might not create the difficulty of pages coming apart.
Yes.
I've got 14 pages to fix.
My worry is that it may occur again.
Yes,
So
it might
may
occur
simply
again.
be easier to put it
Yeah,
in a
let's do
lever
it
arch
that
file.
way, yes.
Chair, while that's being done, Ms.
Yes.
Viljoen, you don't need to trouble yourself with those papers. You'll get a replacement file now that will be easier to turn over.
I'm done. It's going in, and then I'm done, and it's fixed, and I'll make sure it
No,
doesn't come undone.
She's very passionate about wanting that one.
That is fine.
Let's
It
leave
looks
it like
pretty.
that. She promises it won't come apart
It won't come
again.
apart again. Well, we will have on standby
And
just
that
in
promise
case.
is under oath, so.
We'll
Okay.
hold you to it. Ms. Viljoen, you were about, however, to give us some background to the genesis of that last affidavit. You mentioned Mr. Udeel. Can you tell us the circumstances in which it came to be produced, this affidavit, at page 91?
Mr. Judil called me and asked for a meeting.
When was that?
it would have been more or less around this time.
December 2017?
Yes.
Thank you.
And
And tell us before you proceed who he was or he is.
he presented himself as a private investigator.
And what did he say to you?
In all honesty, I forgot about this until you sent me the statement. But it was a quick meeting at a Mug and Bean, and he asked me about the transactions. I went and I looked at the transactions. He took notes, he wrote the affidavit, he emailed it to me, and then I just signed it.
How did he obtain the documents that are attached to it?
I sent it to him.
So let me just get clear.
Sorry, I might have given it to him, but yeah, I gave it to him.
And that was at a face-to-face meeting in December 2017?
If memory serves me right, yes.
So you were contacted. Did he make reference to a criminal case?
I'll have to lie if I answer that. I cannot remember. It was December. We had family coming over from overseas. So I have to, it was a brief meeting, and I cannot remember if he made reference to it or not.
So when you signed the affidavit, did you look at the first page which says Mafeking CAS 4908 2017?
I did see it, yes, but that doesn't really mean anything to me.
Right, but you considered the contents and you were satisfied with their correctness, and so you signed it. Is that right?
Yes, Chair.
And at some point, either prior to that meeting or thereafter, you gave Mr. Udeel the documents which are then attached to that statement, because those documents originate from you, correct?
Yes, Chair.
Did you meet with him and Ms. Captain Mahosi?
No, Chair.
Were you aware in the evidence over the weekend that Ms. Tlatsana indicated that Mr. Udeel had said to her that he attended with Captain Mahosi when he met with you?
I saw it, and no, he was not with Captain Mahosi.
So why did you agree to meet with him and depose to an affidavit then?
He asked very nicely.
What was that answer?
He asked very nicely, can you please meet me?
Okay, all right.
But you were under no compulsion to do so. You didn't have a sense that it had anything to do with a criminal investigation
No.
or any such thing?
No.
We will return to that in due course in the evidence. Thank you. Ms. Viljoen, I'd like to begin at page 1 then of your affidavit to the Commission. And in paragraph 3 on that page, you start to explain to us about an entity called Asset Movement Financial Services, CC. Chair, we have previously in the evidence been referring to this entity as AMFS. We may do that in the course of the evidence, but that will then be a reference to this CC, which I understand you established to run the business.
That's correct, Chair.
And tell us what exactly that business was. And for that purpose, I'd like us to go to the company profile that you've provided in various of these affidavits. There are a number of copies, Chair, in the papers. The best copy I could find at page 48. So if we go to page 48.
Yes.
You'll see a 25th February 2015 company profile. Can you confirm that that's your profile of the company, Ms. Viljoen?
Yes, it is, Chair.
And then if we go over to page 50, you usefully give a description of your business there in the top paragraph. For the purposes of today's evidence, can you just explain to us what that business was?
It was a cash and transit business.
And what does that mean?
It means that if a business would need money, we would deliver the funds for them.
Thank you. And can you just give us a sense?
I'm sorry. You would take funds from a business to deliver or cash from a business?
We will pick up the funds from a bank and then deliver it to clients that might need funds.
Yes.
Like
and
a
vice versa.
G4S, yes.
And vice versa. So you
we
would also
didn't-
take from a business
We
to go and
didn't
bank
really
for
do
them.
collections,
You didn't do the collection from
No.
the business. You only did one way.
yes.
Okay.
Can we just have that again? You said you didn't really do collections. Did you ever do collections?
Not to my recollection.
Thank you. And then just in terms of the industry in which your business was operating, how big is the market? Did you have lots of competitors?
I would say it is big. G4S, Fidelity, Coin, SBV, it's a big industry.
And did they all operate a similar business model to yours?
I cannot comment if their business model was the same as mine.
But your sense is it's a big market and there are a number of competitors in it.
That's correct, Chair.
You know at least of one business that operated a similar business model, don't you? That was your previous employer, is that correct?
That's correct, yes.
And what is the name of that employer?
A Rustic Stone.
Thank you. We'll come back to just a few more details about Rustic Stone in a moment, but I'd like to continue on page 50, because on that page you set out some further details about your business and its Yes, it's hard to believe, I know, because 50 is not clear at all.
Yes.
What we may seek to do, Chair, is just get a better copy from Ms. Viljoen.
We can do what we can with
Yes,
this.
with this,
Do with
indeed.
it.
And given
Yeah.
that it's her document,
Yeah.
where it is relevant for us to know precisely what is
Yeah.
said on the page, I'll ask for
Yeah.
Ms. Viljoen's assistance.
That's fine.
If we may proceed on that basis. And Ms. Viljoen, that takes me to the next question, which is midway down the page, there's a heading there, which I read to be company ownership / legal entity. Is that a correct understanding of what's...
That's correct, Chair.
And then you say under that, as I have it, AMFS is registered. And it says all required certifications will be acquired and maintained at all times. And then all legal compliance to legislation is and will continue to be maintained. Is that an accurate reading of what is reflected there?
I would say so, Chair.
Let's just pause on that question of legal compliance. I assume it was important for the operation of your business that you ensured that you complied with the applicable legislation. Is that right? If you
Yes,
give an
Chair.
answer, thank you. The record has to have your answer verbally. Then I'd like to just explore a bit what that legislation was. Were you compliant with the Private Security Industry Regulation Act?
I was, yes.
Can you just give us a sense of what that legislation regulates?
I'll have to check, I cannot remember.
Okay,
But we had to be part of CIRA, register the company under CIRA and register all the people that was working under CIRA, and we were.
Right. And then legislation that's colloquially called FICA, the Financial Intelligence Center Act. Were you compliant with that?
I FICA'd all my clients, yes.
Well, what does that mean?
I would obtain copies of their IDs, their income tax numbers, all the details required by FICA. I would get that from the clients.
So did you regard yourself as obligated under FICA to do so?
Yes.
Okay, that is certainly consistent with what you say at page 5 of your affidavit. If we go to page 5, Chair, and Ms. Viljoen, you'll see at the top paragraph on that page, under 5.1.1 towards the end, you say, I will deal with the onboarding process of each. These are the types of clients you're going to describe in turn, and the steps that I took to ensure compliance with AMFS's FICA obligations. You see that?
I do, Chair.
So as part of the statutes that you needed to comply with in order to conduct your business was FICA. Is that correct?
That's correct, yes.
I'd like for this purpose just to go to FICA for a moment, because one of the chapters that's particularly pertinent to today's proceedings is the chapter dealing with control measures for money laundering. Chair, you'll find it in the legislation bundle, and Ms. Viljoen, And the Financial Intelligence Centre Act, which we'll refer to as FICA, is under tab 5, and it commences at page 110. And if you go to page 121 in that bundle, you'll see chapter 3, 2/3 of the way down the page, which is headed Control Measures for Money Laundering and Financing of Terrorist and Related Activities. Chair, we'll return to the pertinent provisions in due course in Ms. Viljoen's evidence. But what I'd like to just be clear on, Ms. Viljoen, is were you concerned to ensure that all the necessary regulatory and legislative requirements were met by your company?
Sorry, can you just say that again?
Were you concerned to ensure that you complied with all of the requirements of FICA in the operation of your company?
Yes, I tried my best, Chair.
And I assume that that would have included the measures that are put in place under FICA to guard against businesses being used for money laundering. Is that correct?
Yes, Chair.
And then in terms of your role or status under FICA, which of the accountable institutions under FICA did you recognize your business as?
A money remitter.
Thank you. And what is your understanding of a money remitter?
A cash in transit business.
And why is that?
Because we remit money.
Did you seek legal advice on that?
I did, yes, Chair.
Amongst the governing documents in relation to FICA are also a series of guidance notes that the Financial Intelligence Centre issues from time to time. Did you ensure that you kept up to date with those?
I did not, Chair, no.
Do you know that you're legally obliged as an accountable institution under FICA to do so?
I do now. Thank you, Chair.
I'd like to just take us to one of those guidance notes, which we've put in the bundle. Chair, you'll find it, and Ms. Viljoen, at page 159.1. It's a guidance note issued on the 14th of March 2008. Ms. Viljoen, have you seen this before?
No, I haven't. Sorry, which page?
Apologies. 159.1. And it's dated the 14th of March 2008. And you'll see on that page, in terms of its title, it's Guidance Note 4 on Suspicious Transaction Reporting. Have you seen this document before?
I have not, no, Chair.
We'll go to it at the appropriate time in the evidence. But as I have it so far, you accept that you're an accountable institution under FICA because you identify your company as a money remitter, correct?
That's correct, yes, Chair.
But you have not kept track of, amongst other things, Guidance Note 4 in relation to suspicious transactions that require reporting.
No, Chair.
Thank you. I'd then like to just move over to page 2 of your affidavit, if we may. Because there at paragraph 3.4.
I'm sorry, did you say you're going back to her affidavit?
To the affidavit, indeed, Chair,
Okay.
at page 2. We'll pick it up.
Thank you.
And on page 2, we are at paragraph 3.4, because, Ms. Viljoen, as I read paragraph 3.4, you explain in that paragraph why at a point in time you had to hand over the books and records of your CC. Is that correct?
That's correct, yes.
Can you tell us about those circumstances and what happened?
It was a case with Small and Medium Business Bank of Namibia, and they opened up an inquiry. And
A liquidation inquiry?
Yes, they did. And they then asked for us to hand over our documentation.
And
I'm sorry, just before we proceed, we know what business your entity was involved in. From where did you operate?
From Springs.
From Springs?
Yes, Chair.
And your clients would be around Springs only, or you
no,
went
Chair.
beyond, what was this?
Gauteng.
The whole of Gauteng?
Gauteng, yes, Chair.
Okay, thank you.
Thank you,
And
Chair.
just the size of your operation, about how many employees did you have, for example?
We were a small team. There was four drivers, so it was a small team,
Yeah.
but we were busy.
Okay, all right. No, I just wanted to, so that we know exactly from
Indeed.
where you operated and what was the area in which your business was active.
Chair, I do plan to go into that in more detail
Yes.
in due course.
Yes,
But that
that's
is
fine.
useful background for the purposes of understanding your handing over of your records. So you were explaining, Ms. Viljoen, that there was a liquidation inquiry into the Small and Medium Enterprise Bank of Namibia. Is that correct?
That's correct, Chair.
And in the course of that, you were asked to hand over certain books and records. Is that correct?
That's correct, Chair.
Can I just get clear on what books and records you handed over
I handed over all books and all records.
of your entire business?
Yes, that's correct.
Even though the entire business would not have related to the Small and Medium Enterprise Bank of Namibia.
They've asked for it and I handed it all over.
How precisely did they ask for it? And I'm asking that, Ms. Viljoen, in fairness to you, because the powers of the master under a liquidation inquiry is to demand by subpoena documents that may be relevant to the company in liquidation. But the powers do not extend beyond that. So are you quite sure that you did not get a request for the documents and books related to the company in liquidation?
I do not recall getting a summons. We were at the Commission of Inquiry and they asked for it and we handed it over.
Every single
Everything.
related beyond the Small and Medium
Yes, that's
Enterprise
correct.
Bank?
That's correct.
Did you take steps to recover all the documents of your business
Not
thereafter?
yet, no.
Did they say, thanks for these 37 files, but we're only interested in 2?
No, they did not.
And to whom were they handed?
To the liquidators. They came and they collected it from my lawyer's office.
I'd then like to just be clear about precisely what documents were given to them, if we may.
Okay.
And you'll find at page 17 of your bundle the letter that you have provided to us, which I understand is the covering letter when you handed over these documents. And you'll see under 2, you say, kindly find 34 lever arch files and 1 plastic folder containing, to the best of our client's knowledge, the full books and records of account for Asset Managed Movement and Financial Services CC. Do you see that?
I do, yes, Chair.
That suggests to me that it was accounting records that you were handing over, the
It
books
was
and records of
everything.
account.
It was everything.
But can we pause on the description there? The full books and records of account, you're saying that isn't confined to accounting records,
It's got the accounting records as well.
including others.
Yes.
So let's just go through what those others would have been. What else was handed over?
Well, it's all just the accounting records.
So
it would have been the bank statements, it would have been receipts, it would have been everything, invoicing, it would have been everything.
So can I just go through a list that I've compiled and you can tell me if that's what was handed over? Invoices,
Yes, Chair.
your monthly reconciliations, of
Yes,
which there
Chair.
are some examples in the papers, delivery slips.
Yes, Chair.
So every single delivery slip of your business was handed
It should
over
have
to the
been in the
liquidators.
files, yes, Chair.
Just let's pause there, should have been. Did you satisfy yourself as to what was in the files when you handed them
I
over?
literally just took the files, or actually it was with my bookkeepers in their storage unit. So I went and I just took everything that was with my bookkeepers and I dropped it off at my lawyers and then they collected it. So everything should have been in those files.
Did you keep management accounts?
Yes, Chair.
So that would have gone as well?
That would have been in there, yes.
And financial statements?
No, that would not have been in there, no.
Why not?
I had a separate file for financials, Chair.
And anything else other than those that I've listed that you can recall?
I now can't remember, but it would have been everything.
Documents that you had compiled for the purposes of vetting your clients, would that have gone as well?
It might have been. I cannot confirm.
It seems to me, Ms. Viljoen, and I'm asking this in fairness to you so we can get clarity on it, the focus was, as I've suggested, the accounting records, the evidence of the deliveries, etc. It may not have extended, though, to documents that you compiled in the course of vetting clients and establishing who they were. Is that right?
It could have been. I cannot remember what was in that clear folder. I cannot recall what was in there, so I can't remember. But I gave everything over.
You did so under subpoena, did you not?
Again, you've asked me, and I don't think I was subpoenaed to hand over the documents.
The language you use in your affidavit is that you were ordered to do so. What did you mean when you said ordered at page 2, paragraph 3.4?
Well, I wasn't ordered, I was asked.
You were asked.
Yes,
Thank you.
Chair.
So it may not have been pursuant to an order from the master.
Correct, Chair.
Who asked you?
The liquidators.
The liquidators?
Yes, Chair.
Did they speak to you directly, or they spoke to your attorney and your attorney
They
told
spoke
you?
to both of us, and
Yeah.
they asked us for the files,
Yeah.
and then afterwards they would have spoken to my attorney.
Also, your attorney was present when they spoke to you?
That's correct, Chair.
Okay, thank you.
And just to be clear, they asked you for all the files of your entire business.
I would have to lie to answer if they asked
You're
for
not
that.
sure?
Yes.
You're not sure if they asked for that, but you're sure that you gave everything.
I gave everything, yes, Chair.
Do you have a recollection of what your impression was of what they asked for? Is it that, at least your understanding, is it that they wanted everything?
It might have come across like that, Chair.
Yeah.
I'm not sure, but I don't want to say it came across like that and then it didn't, and so.
Yes, no, I understand that, but at least I think you gave everything because you probably thought they wanted everything.
They can have
That was
everything.
your understanding. They might or might not have said so, but
I just gave
You wouldn't have
everything
given them
in case they
everything.
might wanted to come back and ask for more,
yeah,
so I gave them everything.
Okay.
Yes, Chair.
Did you keep copies of what you gave over?
I did not know, Chair.
You didn't have electronic versions of those?
For some things, I did have electronic copies.
But not others?
No, not for everything, not nearly everything.
Do you know that under FICA, as an accountable institution, you have to keep all the records of your business for a minimum of 5 years?
By then, the company was liquidated.
Can you answer the first question? Do you know that you have to, by law, keep the records
I
of the...
did not know.
You did not?
No, Chair.
Do you know whether your attorney kept a record of what was handed over to the liquidators?
My attorney,
Yeah, do you know whether your attorney kept a list of what was given to the liquidators or not?
I'm sure he might have. I can't answer.
Well-
I'm not sure.
Well, no, you can answer because you either know or you don't know.
I don't know, Chair.
Okay.
But just so I have your evidence correct, you were not aware that under FICA you're required to keep all the records for a minimum of 5 years?
Can I answer that in a 2-point? So when the business is liquidated, liquidators that liquidates the business then take all the files over, and then they are legally apparently not my files anymore. That's how it was explained to me. So the business was liquidated, and then the files were to go to the people that liquidated the business. But then just after that, the liquidators of SME asked for those documents.
Okay, we're dealing with a few liquidators here. Let's deal first with your business.
Yes. So as it was explained to me, that when you liquidate your business, then the liquidators of that business takes possession of all your files. That is how it was explained to me. And then afterwards, SME liquidators requested for the files, and so we handed the files over to them.
So you had to get them back from the liquidators?
We still had to take them to the liquidators. They were still with my bookkeepers, and we still had to take them to the liquidators.
Your liquidators?
Yes.
So let's just get that chronology right, if we may. When was your business liquidated?
It was in the start of 2018.
So who at that point has all your records?
My bookkeeper still had all my records.
So when did you give them to the liquidators?
I think it was end of 2018.
So after you gave all of them to the liquidators of the Small and Medium Enterprise Bank?
Can you repeat that? Sorry?
You gave all the records to the liquidators of the SME Bank of Namibia
Yes.
in October 2018.
I cannot confirm if it was in October, but it was end
It was in October because that's when the letter that you put up went
yes,
to the
that's
lawyers.
when we did it. Yes.
So I just want to understand, did your liquidators have them then?
No, they were still with the bookkeepers for some reason. I don't know why, but they were still with the bookkeepers for some reason.
But if they went from the bookkeepers to the liquidators of SME Bank Namibia, then they've never gone to your liquidators.
They should have apparently gone,
To your knowledge,
to my knowledge.
have they
yes.
gone to the liquidators of AMFS?
No, not
Right.
to my knowledge, no.
So that is not why you didn't retain the documents and records for 5 years, correct?
That's correct, yes.
Did you give instructions that those books be given to the liquidators of your closed corporation at any stage?
I don't recall giving instruction.
Yes. No, it's just that you, as I understand your evidence, you say before the liquidators of the SABC Bank.
Indeed, Namibian Bank, we can maybe refer
before
to.
the liquidators of the Namibian Bank approached you for those books or documents, you say those books or documents should have gone to your liquidators.
That's correct,
Did
Chair.
I understand you correctly?
That's correct, Chair.
Why do you say they should have gone?
Um,
How is it that they should have gone there if you had not given instructions that they be taken there? You were the owner of the business, as I understand.
I cannot recall if my bookkeeper had to finish things or why it never went. I cannot recall, and I don't want to say now that it's for this reason or
Yes.
for that reason,
Had
but
they
I cannot
been
recall.
asked for already? Had your
They have not
liquidators
asked for it yet, no.
Yes. Okay, but what is it that makes you say they should have gone there already?
That is how they explained it to me, that all my books will then have to go to them.
That is your liquidators.
That was my bookkeepers.
Your bookkeeper told you
That's
so.
how they explained it to me, yes.
Oh, but it's not your liquidators who said that to you.
No, they didn't say that.
But did you say to your bookkeepers, okay, in that event, you must take the books to the liquidators?
I don't recall saying that.
Yeah. Well, okay, English is not my first language. I don't know if it is yours, Ms. Viljoen, but it may be that the problem is the use of the word should.
It may well be, Chair.
yes,
For our
yes.
purposes, the most important aspect I'd
Yeah.
like to get clarity on. It's first, and you will correct me if my summary is incorrect, Ms. Viljoen, you were not aware of your obligation as an accountable institution to keep your records for 5 years.
No, Chair.
You didn't know of that obligation under
No, Chair.
FICA. When I probed with you why it was, as a matter of fact, irrespective of the legal obligation, that you didn't retain your records for 5 years, I understood your answer to in some way relate to the liquidation of your business, correct?
Yes, Chair.
But as a matter of fact, you do not know whether the records of your closed corporation ever ended up with the liquidators of that closed corporation, correct?
Correct, Chair. It ended up with the SME liquidators.
Yes,
Yes.
but not yours.
No.
Thank you. We'll return to those provisions, Chair.
Well, just so that we clarify, whether they ever reached your liquidators, is that something you know, or is that something you don't know?
I know it didn't reach it, Chair.
Oh, it didn't go to them.
Yes,
Okay,
Chair.
no, that's fine. Thank you.
Chair, we will return to those provisions in relation to the records, because in due course I'm going to ask for Ms. Fillion's comment on the extent of the obligation under that
Yes.
section, albeit that she's told us already she wasn't aware of it.
Yes.
I'll ask for her comment on it when we look at the section.
Yeah, that's fine.
And then, Ms. Fillion, if we can go back to the series of questions that the Chair began asking you about the formation of your business. I'd like to get some detailed background there, and I have it commencing in your affidavit at page 2 under the heading 4, background. Now, you begin, as I read your affidavit, explaining your prior employment at a business called Rustic Stone. You'll pick that up in paragraph 4.2. Can you tell us about that employment and its duration?
They were a cash and transit business, and I started with them around 2012, and I finished up, I want to say it was October 2014 I left to start AMFS.
And Ms. Fillion, I had it from your evidence previously that they operated a similar business model to AMFS. Can we take it that what they were doing at Rustic Stone you then replicated in AMFS in terms of the business approach?
That's correct, yes.
We'll explore that in quite a bit more detail in due course, but I just wanted to be clear. Rustic Stone operated in the same way as AMFS when you set it up, correct?
That's correct, yes.
And then tell us about how, from Rustic Stone, your closed corporation came to be formed.
One of the clients from Rustic Stone approached me and suggested that I start my own entity.
Who was he? Who was the client?
Andries
Andries who?
Cravenstein.
Thank you.
And he then said he'll help with the funding. And yes, that's how AMFS was started.
I picked that up at page 3 of your affidavit from paragraph 4.6. That is where you reference being approached by Mr. Cravenstein, who I understand was an existing client of Rustic Stone. I understand there that he provided initial funding to establish the business. Is that correct?
That's correct, yes.
And any other role that he played in the business?
No role.
So he wasn't a member of the CC?
He was a member of the CC until I paid back the initial loan, and then he went off as a member of the CC.
And just tell us that timeline. When was the CC established, and when did Mr. Cravenstein leave as a member?
It was established around 2015, January 2015, and he either left the CC at the end of 2015 or the start of 2016.
And from that point, if I pick it up at paragraph 4.8, who were the members in the business?
Just myself.
So
Chair.
you had 100% members' interest?
That's correct, Chair.
You go on in that paragraph 4.8 to say that at no time was Andries, I take that to be a reference to Mr. Cravenstein, involved in the running of the business. Is that correct?
That's correct, Chair.
Where did your business operate from?
From his premises at the back.
Did it always operate from his premises at the back?
No. Eventually, I started working from home.
So when did that change occur?
More or less the same time that the business was handed over.
So can I just get that correct then? The business starts end of 2014. I have it in your affidavit that you purchased the shelf CC. So we could maybe take it from end of 2014 to end of 2015, you operated from his premises. Is that correct?
That's correct, yes.
Then he sold out of the closed
correct.
corporation in early 2016. And do I have your evidence to be from that date onwards, you no longer operated at his premises?
It was still registered there, and the vehicles would sometimes be parked there. But I no longer had my little office there, if that makes sense.
No, it does, but I'd just like to get clarity. Did the vehicles of the business continue to be parked there throughout the AMFS existence?
Right to the end, sometimes the vehicles would be parked there. Yes, that's correct.
So what was the arrangement with Mr. Gravenstein that allowed you to continue to park your
He had
vehicles
premises right next door, and he wasn't using it, and he said we can use that to, if we needed to use it, we can use it for the parking of the vehicles.
So he did continue to have some involvement in the business, but it is confined, I understand, your evidence to allowing your vehicles to park on his premises.
That's correct, yes.
There was
Chair.
no other role that he played
No,
in the
Chair.
business. And then if we move down to paragraph 4.9 on that page, you talk about the profitability of the business. Can you please assist us with information about how much money was moving through the business at its peak?
About 500 million
Over what period?
per month.
So at its peak, R500 million was moving through the business, correct?
That's correct, yes.
When did the peak start and when did it end?
Oh, no, I can't recall that.
Well,
Chair.
let's just go through just an order of magnitude. As I have it, your business operated from early 2015 till March of 2018. Is that correct?
Until I sold the business in October 2017, and the final handover was done in November 2017.
Oh, right. The liquidation happened in March 2018.
And then, yes.
Okay, so let's just get the timeline right. Beginning 2015 to, let's call it October 2017. Are you comfortable with that?
That's fine, yeah.
So that's about 2 years and 10 months?
3 years, yeah.
Okay, I'm just trying to get a sense of those 2 years and 10 months, how much of it could be described as the peak?
2016 was a good year, and so was 2017 as well. 2015, because we had the robbery and we had to outsource, it was profitable, but not as much as maybe August 2016 going into 2017.
Okay, so would it be fair to say that there was about R500 million moving through your business for at least a year of its existence?
We can say that, yes, Chair.
Thank you. Ms. Viljoen, I'd next like to move to the process you use to vet clients, and we can pick that up at page 4 of your affidavit under a heading Client Vetting and the Delivery Process. Before we get into its details, though, I'd just like to get a sense from you about the importance you placed on client vetting. Did you regard it as an important aspect of your business?
I did, Chair.
And were you aware of the ways in which accountable institutions under FICA are required to vet their clients?
I did know, yes, Chair.
We can go to those provisions in due course. I also just want to know, we looked at Chapter 3, which is a series of control measures under FICA to try and prevent the use of businesses for money laundering. Do you know what money laundering is?
I do, Chair.
So can I take it that it would be part of the reason for vetting clients that you equip yourself as a business to guard against money laundering? Is that fair?
Yes, Chair.
And can I also just, for preparatory purposes, get an understanding that whether you agree that there can be a link between money laundering and corrupt activities? Do you accept that there's a link between those two?
Yes, Chair.
And just to explore that a bit further, it seems to me that the link lies in the fact that corruption is about paying people off for favors that they give you. Do you accept that very basic explanation?
I do, Chair.
And one of the ways that that can...
Your loose definition is too loose.
Too loose. I'm happy to employ the legislative definition.
I'm allowed to pay my daughter for her to do a favor for me.
Indeed, Chair. I should have added a favor that it is not legally permissible to be made. Indeed, Chair. I'm indebted to you. We can actually pick it up in the Prevention of Organised Crime Act. And also PRECA has a useful definition of corruption. But maybe for present purposes, I think the refinement was critical. It's paying a benefit to receive a benefit yourself to which you are not legally entitled. Are you comfortable with that definition?
I understand, and I'm comfortable with that, Chase.
And then just in terms of the link between money laundering and corruption, money laundering, and correct me if you have a different interpretation, is about disguising or concealing the true nature, source, location, or movement of unlawful proceeds. Do you accept that?
I do, yes, Chair.
So the one way in which corruption can be facilitated is if you render money in a way that its true source is not clear, in order for those who must be repaid for the illicit favor you've received, then getting money. Do you accept that?
I do, Chair.
Thank you. Let's go then to your process for vetting clients, because it begins at page 4 of your affidavit, but it really gets into its detail over the page at page 5. Do you see that?
I do, Chair.
And we commence at paragraph 5.1.1 because as I read that paragraph, you draw a distinction between new and existing clients. Can you explain that difference to us?
New clients would be people that I did not have prior workings with at Rustic Stone, where existing clients were clients that came from Rustic Stone to asset movement and financial services.
And just to tie one loose end, what is the position that you held at Rustic Stone?
It started off where I was doing the administration, and then eventually it involved where I was ordering the funds, and I was much more involved in the day-to-day runnings and not just...
Yes, no, I saw that's what you say in the affidavit, but I want the job title. Were you manager something? Were you consultant?
They never gave me a job title.
Oh, okay, all right.
And just so I can get clear about your difference in approach on vetting between new and existing clients, I understand from what happens later in your affidavit that relates to whether they were required to sign standard terms and conditions. Is that correct?
That's correct, yes.
Is that the only difference?
That would have been the only difference.
So even if it was an existing client that you knew at Rustic Stone, you'd still go through a vetting process. Is that correct?
I would, yes, Chair.
And tell us what that vetting process comprised, please.
I would get their ID number, income tax number, address. I would go visit the address and make sure that they are who they are. I normally like to visit the address as well to see if it was a security risk for my men to go and do the deliveries. I would get their telephone numbers, and that's it.
And if we go on page 5 to paragraph 5.1.2.3, that's where you move from the description you've just given of the various documents you sought and inquiries that you made. And you go on and you say, once I'd received the above completed with copies of all supporting documents, I would conduct various trade inquiries, and if all added up and I was confident that the request came from a legitimate business, I would conduct a site visit to confirm the address provided and also to consider same from a security point of view. I would like to just unpack that a little bit. What various trade inquiries would you make?
I would ask them, what do they do? So I didn't find different sources to verify it, but I did sit with them and find out from them if it was a good business, what they do.
And did you keep records of that information?
I never took notes, no. I was just, it was a discussion.
So you weren't aware under FICA that you were required to keep a record of that?
No, I wasn't, Chair.
And then you go on and you say, and if all added up, and you were confident that the request came from a legitimate business. Just help us there. What would equip you to know if it added up?
If they seemed like a real business, if they seemed, that feeling you get inside of you that everything's okay.
And let me just be clear about this. Would you meet them always at their businesses when you had this discussion with them?
Yes, because I wanted to do the site visit and see if it was safe.
So you always met them at the business?
I would say yes, Chair.
And you had a bit of a discussion, and then you got a feeling about whether it was a legitimate business, and on that basis you'd continue to conduct business with them?
That's right, Chair.
And are you aware under FICA of your obligations to establish the source of funds of any business that you enter into a business transaction with?
No, Chair.
Not aware of that?
No, Chair.
I take it your affidavit description talks about this one initial engagement, where if you're satisfied, then you regard it as acceptable to continue in business with that entity or individual. Is that correct?
That's correct, Chair.
Did you do any follow-ups in relation to the businesses?
No, Chair.
I take it then you aren't aware that under FICA you were required to do regular due diligences of the businesses with which you transacted.
What due diligence would that be, Chair?
To continue to check the source of funds of the businesses with which you transacted.
No, Chair.
So you would satisfy yourself at the commencement of the business relationship that
Everything was in order.
That they were legitimate business, and everything seemed to be in order, and thereafter, as long as you continued to have that feeling that they were fine,
That's correct, Chair.
you would not do any further check.
No, Chair.
Okay.
Then let's move to the terms and conditions. I understand your evidence to me sometimes they were signed, sometimes they weren't. Can you just take us through how that happened?
Where are we now?
You talk about, at the bottom of page 5, paragraph 5.1.3, you say there, insofar as existing clients were concerned, AMFS would follow all of the above steps, but as there was no obligation on it to have written terms and conditions in place with its clients, as I knew the client already and they were familiar with our terms and conditions of business, I would not insist that our terms and conditions be signed. Do you see that?
So in this case with this specific client, I did send them the terms and conditions, but they never sent it back to me signed.
No, indeed. We'll get to the specific
Yes,
client
yes.
that's relevant to these proceedings. At this stage, I'm just talking generally in terms of your business. I understand you to be saying here that you wouldn't require terms and conditions to be signed with existing clients. Is
That's
that correct?
yes.
How then would you be satisfied as to your legal rights and obligations in relation to those customers?
I was just satisfied. I was happy, I was satisfied. They understood the process, I understood the process. I was satisfied, Chair.
And in relation to new clients?
They signed the terms and conditions.
And
I'm sorry, were your terms and conditions the same as those of your previous employer?
No, Chair.
Okay, so in other words,
So let me maybe explain this. The terms and conditions were the same, but the contract was not the same.
Okay, all right.
Just to clarify.
So the written text differed, is that right?
That's correct, yes.
But the upshot of what
The
you
gist
were
of
doing,
it.
well, the business of Rustic Stone and what its clients could assume would happen in the business, what your obligations were and what their obligations were, was the same when you moved into AMFS, is that correct?
The gist of it was the same, correct.
Then I would like, so we've done the process as you had developed it for vetting. If you go over the page to page 6, you then tell us how the cash delivery process would work from AMFS. And I'd like us to please go through that. You set it out in some detail there, and the detail is important. So if you could take us through each of the steps for how you would process a delivery of cash.
Okay. My client would contact me saying they need a certain amount of funds
Can we just stop there? How would they contact you?
with a phone.
Thank you.
I would then compile all of that and send it to the service provider, and then they would pack the funds into clear bags and make sure that it's been counted, and then my drivers would go and pick it up and do the deliveries afterwards.
Okay, if I may, I'd like to unpack that a little bit further.
Okay,
So it starts with a telephone call from a client.
that's correct.
What does the client say to you on the call?
We need a certain amount of funds.
Right. Then what would happen?
Do you want it now?
In detail.
In detail,
Let's
okay.
go through a day in the life of AMFS, right?
Okay.
Because I understand these transactions happen within a day.
Yes,
That's correct.
it's fast.
Right. So you get a call, I assume in the morning.
That's correct,
Let's
yes.
use a hypothetical example.
It is in the morning.
You get a call, your client says, I need 5 million rand in cash today. What is the next event that happens?
I wait for the funds to come in
To come in, so, sorry.
into the bank account.
So they deposit, if I take your language at paragraph 5.1.4.1, they deposit 5 million rand into the AMFS bank account.
That's
Is that
correct.
What
And
happens
and
then?
who is they now?
The client.
I thought you said earlier on they would say they need so
Yes.
much.
So they would say to me, they would call and say they need 5 million, and then they would transfer the 5 million into the account.
When they
into
say
my
they
bank
needed
account.
like 5 million, did that mean they needed you to transfer 5 million for them?
No,
What did
no,
that
no.
mean?
I'm going to explain the whole situation.
Well, I
now,
want to
and then we
understand
can
the
come-
need first. You
They
were
would
asked
like
what
to
they
have-
would say to you.
They
Yeah.
would like to have 5 million. They are ordering 5 million.
Now, when they said that, were they asking you to give them 5 million rand? that
No,
day?
Chair.
What did that mean?
It meant that they're ordering 5 million
Ordering from whom?
from me.
You would have money and you would give
No,
it to them.
Chair, no. I would then go on and order it from the service provider.
In your name,
Yes, Chair.
the service provider being a bank.
It's SPV, and the 4 banks own SPV.
Oh, okay. Would the service provider always be SPV?
Yes, Chair.
Okay. Now, I think you just said that, or something that I understood to be, the client would provide money to you. Or did I misunderstand?
Yes, so they would order the funds from me, and then they would transfer the funds into my account, and then I would transfer it into SPV's account, and then they would pack it and make sure that it is the right quantities as we need it.
The they is your client. Initially,
excuse me?
they phone you. Is that your client?
Yes,
They say
Chair.
they need money.
Yes, Chair.
That's your client still.
Yes, Chair.
And then they, being your client, transfer money into your account.
That's right, Chair.
That's the part I don't understand.
Indeed, Chair. If I may be of assistance.
Yes.
When they say they need 5 million, Am I correct in understanding they are saying they need 5 million in cash?
Oh, that's correct, yes.
Right. So they have 5 million in their account.
That's correct.
Because otherwise
yes.
this transaction is not going to take place.
Yes, it can't.
Right.
SPV.
Your client phones you in the morning, they've got 5 million in their account. They say, we want this 5 million in cash today.
That's correct, yes.
They then transfer the 5 million into your bank account, AMFS's bank account,
That's correct, yes.
Because they want within the day that 5 million rand that comes to you in an EFT to be converted to cash to be delivered to them, correct?
That's correct, yes.
Right. Let's just go.
Okay, now I think that's helpful. So they've got 5 million, but not in the form of cash.
That's correct, yes, Chair.
And they want you to take whatever steps you need to take to provide them on that same day with cash to the value of 5 million.
That's correct, Chair.
Okay, now I understand.
Right, so we're at the point at which, because the sequence is very important, that's why I'm wanting to break it down. You get your call, your client says 5 million rand is going to come into your account today, I need that cash. What then happens?
So if the funds come into the bank account, I will call the client and confirm that it's their funds.
Okay,
And
if
then-
we can stop there just for a moment. So you've got a call in the morning. Now, are you watching your bank account?
I do. And I had the text message alert that come through as well. But I am watching my bank
And how many
account.
calls are you getting on an average morning?
So by the end of 2017, I would get up to 100 phone calls a day. My phone never stopped.
Okay, let's just get it right. You're getting 100
Business was good.
This was 2017, yes.
in your peak of 500 million rand a month.
It was busy.
Right. So you get a call in the morning from about 100 people who say, this is on average, they need cash in various amounts, correct?
That's correct, yes.
Then you watch your bank account for when those funds come in, correct?
That's correct, yes.
Now, if there are 100 that are coming in the course of a morning, how do you work out which of those payments relate to which clients?
So some of the reference numbers I would recognize, but the ones I didn't, I would call the client and say, money has been deposited in my account, can you confirm the reference? And then...
Can I just there. So it wasn't a requirement of your terms and conditions with your clients that they use a particular reference number?
No.
So sometimes you'd be lucky enough to recognize a reference number that would relate to a particular client.
Yes.
Would you then regard that as satisfactory indication to you that the cash should be delivered to them?
That's correct, yes.
But sometimes you'd get other references, correct?
That's correct, yes.
Like BK.
That's correct, yes.
And then what would you do when you saw BK come in with 5 million rand, for example?
So the client that would have called saying that they want 5 million, I would call them and then confirm whether it's their funds. What's the reference they used?
Yeah, just finish.
That's all, Chair.
Were the requests always telephonic and not in writing, or
No,
sometimes
Chair.
in writing?
Some of them were in writing, Chair.
By way of email?
That's correct, Chair.
Okay.
Give us a sense of the order of magnitude. How many were telephonic and how many were email, just in a proportion?
I cannot answer that. I would say most of them were probably on phone.
Well, that's certainly consistent with what you say at paragraph 5.1.4, because there you only speak about being contacted telephonically by a representative. So the majority of these requests are coming in on phone, correct?
That's correct, Chair.
Okay, so now we're at the point.
I'm
Apologies.
sorry again. So, would some of the requests be by way of SMSs or WhatsApp, just for the sake of completeness?
I
You are not
can't
sure?
recall if people SMS. It was majority phone calls.
Okay, no,
Yes,
that's
Chair.
fine. So effectively, when you were delivering cash to a client, to the value that the client had specified in their request in the morning, you were basically giving them
Their own money back.
their own money back.
That's correct, Chair.
Yes.
Yes.
In cash form.
That's correct, Chair.
Yeah, and you retained what they had, in effect. They didn't have cash, but they did have 5 million.
That's
They
correct, Chair.
transfer that to you, and you secure cash and give them the cash form of that amount.
That's correct, Chair.
Okay.
Chair, I see we are at the usual time for the tea break. If it's
Yes.
convenient to adjourn now.
Yes, let's take the short adjournment for tea. We'll resume at 11:30.
Thank you, Chair.
We adjourn.
Oh, I'm stuck. I'm stuck.
You may proceed.
Thank you, Chair. Ms. Viljoen, we had concluded your evidence at the bottom of page 6 of the affidavit, just before the break. That's where you were telling us that where you weren't sure of the reference, you'd make telephonic contact back with the client and check with them whether the money you'd received was from them. Is that correct?
That's correct, yes.
Then if we go over the page to page 7, you say at paragraph 5.1.4.5, if the amount and the reference given added up to the amount that was deposited and the reference shown in my bank statement, I would be certain that the funds belong to that client and would then be in a position to deliver the funds to the client. Do you see that?
Yes, I do, Chair.
I just want to explore your statement there that you could be certain of the origin of the funds, having adopted this method. Okay. How could you be certain as to the origin of the funds by using this method?
A strange person that did not do the payment would not know the amount nor the reference.
But you had asked for no evidence of the bank account from which the funds were paid.
No, I did not.
Did you?
I was satisfied that once they confirmed verbally that the funds were indeed theirs.
But then your system allowed a situation to develop, as we will see it did in some occasions,
Yes.
where your client would phone and say, I need 5 million rand in cash, but would then not be the person or entity that in fact deposited money in your account, correct?
This came to light afterwards, so yes.
So when you say you could be certain that the funds belong to the client, that's not correct, is it?
At that point, it was.
Well, let's explore that. If the client simply said to you telephonically, I need 5 million rand in cash, and then subsequently a payment came in that amount, other than phoning the client back for their verbal confirmation, you had no other way of checking that this wasn't proceeds from some other entity,
That's
correct?
correct, yes.
So you couldn't be certain that it was that client's money, could you?
Now, looking at the bigger picture, yes, I was not certain. But at that point, when the client confirmed the name and the amount, I was certain.
You thought you were certain.
I thought I was certain.
Okay.
And then what happens next in the sequence? You can pick that up at 5.1.4.6.
Yes, I would subtract my fee, and I would then consolidate the whole cash order and send it to my service provider. And of course, I would pay the funds over to them, and they would do the packing and the counting, and then my drivers would go pick it up once it's ready.
Let's just spend a bit of time on the service provider. Who was the service provider?
SBV.
And what is SBV?
Again, as I explained to the chair, SBV is owned by the 4 banks.
And what is it?
They do the distribution of funds for the banks.
So are they like a cash warehouse?
They are a cash in transit business, and they are what I can, yes, assume as a cash warehouse. But they do cash in transit as well.
So you are, on your understanding of your business, a cash in transit business, and you receive funds through a deposit into your business's bank account, correct?
Yes, correct.
You then take a fee off that amount, correct?
Correct.
And that fee, as I have it from your affidavit, was in general 0.3%. Is that correct? Then you would pay over the net proceeds to another cash in transit business, correct?
Correct.
And then that business would pack the funds, the money,
Correct.
and your drivers would go and collect it. Is that
That's
correct?
correct, yes.
And then what would happen to the funds?
They would be delivered to the various clients.
And apologies, Chair.
Yes. Please explain to me why any client would feel that they needed your services, because I take it that is if SBV
Our vehicles were
hang
unmarked.
on. If SBV was an entity owned by the 4 banks, big banks, I guess you mean, and they were there to deliver cash to clients, I assume, why didn't the clients who needed your or felt they or contacted you, why didn't they contact SBV or the banks directly and say, I've got money, I've got an account with you, I've got money, I need cash, and then the banks would contact SBV and SBV would deliver?
That is a good question. SBV has got marked vehicles, and most of the clients don't like when a big truck with lots of money stops in front of their premises, and people can then see that they are receiving funds. So our vehicles were unmarked, and then at that point we offered a same-day delivery, where some of the cash in transit businesses did not offer same-day delivery. As for the clients not going to the bank physically, sometimes it's not safe for them to go to the bank to collect funds from a bank.
No, I wasn't suggesting that they should collect the money themselves, but I was talking about why
We
they
had the
wouldn't
unmarked.
get rid of you or not make use of your services. Go direct to the banks, and if the banks say use SBV, because that's the entity we have created, they phone SBV and say, you can confirm with my bank, it's one of the 4, the big 4, I've got the money, but I need cash. And then SBV can liaise with the bank, get whatever confirmation if they need to, but then take the money and deliver it to the client. You have said that some of the clients, maybe all the clients that came to you, didn't want a marked vehicle from SBV coming to their premises, because then
It becomes a
criminals would know
security.
that they were bringing money.
That's correct, Chase.
But why wouldn't SBV provide unmarked vehicles?
No, the unmarked vehicles were our vehicles.
No.
Okay.
From what you have explained to me, the need to use your services arose from the fact that SBV's vehicles were marked.
Yes, that's
And
correct.
clients didn't want to have SBV vehicles seen arriving in their premises, because then criminals would see that money was brought there. So, and I would imagine SBV and the banks which created SBV knew about that concern. And I'm wondering why SBV didn't decide to provide unmarked vehicles.
I
because
can't
then-
answer for SBV.
Because then there would be no need for their clients, for the bank's clients, to spend more money to pay you or services like yours.
Yes, no, I hear what you're saying, but I can't answer for SBV
Yes.
why they don't have unmarked vehicles.
Okay, all right.
Ms. Viljoen, do you know as a fact that SPV has no unmarked vehicles?
No, I don't know that as a fact.
Thank you. Let's just get clear. So you charged a fee of 0.3%.
That's correct, Chase.
Just to follow up on the chair's questions, if this was a transaction just between the client and the bank, do you know whether the bank would charge a 0.3%?
Bank would charge a full percent if they had to go to a branch, and
Sorry, they would charge how much?
a full percent.
A full percent.
Yes.
For a cash withdrawal?
Okay.
That's correct. And then if they went with SBV, because I originally got a quote from SBV before they became a service provider, they would have charged a little bit more than what I charged.
So it seems that there are two reasons. You were charging less and you had unmarked vehicles, but to your knowledge, you don't know whether SBV didn't have unmarked vehicles.
That's correct.
Thank you.
And also we offered same-day delivery.
Do you know whether that could be arranged with the banks?
I'm sure it could. I don't want to confirm or deny, but I'm sure maybe it could.
And then, as I have it, your driver would go and collect from SBV, and then would deliver to the client.
That's correct.
Where would they deliver to the client?
At their premises.
And which premises would those be?
Their place of business.
And would that be the premises that you'd vetted in your site visit originally?
That's correct, yes.
Was that always the case?
Yes, that's correct.
Did
you always have in your records the addresses of each client, the address of each client where cash was to be delivered?
Yes.
Okay.
Given that the questions come up, Chair, maybe we can just go to the checklist that Ms. Viljoen used to complete. I have that at page 29 of the papers. This is in Exhibit DD9. Ms. Viljoen, is this the checklist you'd complete with your clients in the vetting process?
Yes, Chair.
And if you see there, you've got the name of this particular client, you've got an ID number, you've got an income tax number. This is what you went through with us in your previous evidence. And then you have an address there as well. Do you see that?
That's correct.
So is that the address that you vetted for the purposes of this client?
Yes, that's correct.
I think you say that later in your affidavit. So this is your record associated with this client insofar as your vetting was concerned. Is that right?
That's correct, yes.
Thank you.
If your client was a legal entity like a company or a CC, I see here your client was a person.
I vetted the person.
Yeah, you vetted the person you considered to be in charge of the entity.
That's correct, yes.
Yes. Only or also the entity?
No, just the person.
Just the person?
Yes.
Okay.
Thank you, Chair. We'll return to that a little bit later when we get to the details of that particular client. But let's just understand now in the sequence we've got your unmarked armed vehicles going to deliver to the address which is reflected on your checklist for any client, correct?
That's correct, yes.
And then what would happen when they reach the premises?
So the client would, some clients would check to make sure everything was in order because it was packed in clear bags, and then they would sign a delivery slip and my drivers would be on their way again.
Can I just ask above that, I forgot at 5.1.4.8, you say the cash would be packed by SBV in clear sealed plastic bags, and same could be counted without having to open the bag.
Yes.
How was that possible?
So you can count it 10, 20, 30, you can count it. Sometimes there were money missing, like 1,000 rand, but then I just contact SBV with the seal number and I'll say to them, there's money missing, can you maybe just check what happened there?
But you'd be able through the bag at least to see the
more or
the
less,
packs.
yes.
But it would be more or less, because
Yes,
of course if
that's
there's an
correct.
error in putting together one pack, you wouldn't know that.
Yes, correct.
Would your drivers do a general check
Yes, they would.
for the amounts that were being delivered?
Yes, they would.
And then the funds are handed over as I have the evidence, and there's some delivery slip that's
That's
signed.
correct, yes.
What happens to those slips?
Those slips would come back to me.
Well,
The client would keep a slip, and then the carbon copy would then come back to me.
and let's just look at one of those slips, if we may. You have it at you'll find it at 24 in Exhibit DD9.
Yes.
Is that your standard delivery slip?
That's correct, yes.
Is this the same one you used throughout the business of
Throughout.
AMFS?
That's correct, yes.
Let's just look at the bottom one. That is a delivery slip dated the 12th of April 2016. Is that correct?
That's correct, yes.
And how much in cash was delivered to that client on that day?
15 million.
15 million in cash, and the client is, what is the client there? Or who is the client?
G. Markides.
And what is that notation under company stamp?
I would use codes for the clients. So if a slip either went missing or they lost a slip, it doesn't have the actual company details on there, where people might then know there's cash on the premises. So we use codes for our clients.
I'm sorry. Are you referring to the code, to the number below company stamp?
Yes.
So that number that you would write there would represent what?
That would represent a certain client.
A certain client.
That's correct, yes, Chair.
And you would use the same code throughout?
For the same client, that's correct, yes, Chair.
Okay. You would put in that if there was no stamp.
Excuse me, Chair?
You would put the code if there was no company stamp, or you'd put the code
No,
even
we
if
would
there
put the
was?
code down all the time.
All the time.
That's correct, yes, Chair.
And you say the purpose for the code was what?
If this slip had to go missing and someone picked it up and a company stamp was there or the company details were there, they would see that there's funds going to those premises, and it might become a security risk.
Yeah, I'm not sure if I understand that. If you put the number, the code, if there was no company stamp, then I would understand that to many you want to know which client the slip belongs to. But you say even if there was a company stamp, you would put the code.
Always the code.
And you say the code represented
A certain
client.
client, yes.
The code was for your own purposes only.
For my purposes and the drivers.
And would the client know the code?
Some of the clients would know their codes, yes.
Yes. And you said it represented that there was money given to them? Or
It just represents their code.
you created the code, your close corporation, not the client?
That's correct, yes, Chair.
Yes. And you used the code whether the name of the company was there in the document or wasn't there?
We always use the codes.
Yes. But somebody from outside who didn't know what the code represented wouldn't be able to make use of it.
They wouldn't know where to go and look for the company, yes.
Yes. Okay. Maybe it's not important.
Chair, it actually is, with respect. So if I may just follow
Yes.
up there.
Yes.
I understand you to say that you needed to use a code because of concerns about security related to where the monies were being delivered. Is that correct?
That's correct, yes.
Because it couldn't be the identity of the client, because the client's
The
identity
client
is
signs,
here, right?
yes.
I mean, anyone who picks this up knows that 5 million rand has been delivered to Mr. G. Markides, correct?
That's correct, yes.
So, as I understand from your affidavit, the code is to anonymize the delivery address.
That's correct, yes.
And can I be clear?
Can I just add in also, when you are talking on a radio, we would give the code out again so that people don't know.
Right.
Yes.
There'd be no speaking over the radio of the
No names.
actual location
That's correct,
and
yes.
address where it was going.
Yes, that's correct.
So let's just move into the world of cash in transit. You have your people in the armored vehicles, and you say the 15 million has to go to 1010. And then they would know what that means.
Yes, correct.
And if we go to your checklist, which is at page 29, can I assume 1010 is associated with the address that you took
That's
down with
correct.
the checklist, which is 23 Whittaker's Way?
That's correct, yes.
So your drivers would know this is a 1010 delivery, and they would know to take it to 23 Whittaker's Way because it is a delivery for Mr. G. Markides.
That's
Is that
correct.
a fair summary?
That's correct, yes.
Yeah, I think that might be helpful. But why did you, I mean, a code is meant to conceal something from somebody. Now, the purpose of the code was to identify the client and the address where cash had to be delivered.
That's correct, Chair.
Now, if anybody were to, I would have thought that where you have the code, a document that has the code shouldn't also have the name of the client and the address. The two should not be found together. And that what should happen is that
Can I maybe explain
before you do
the
that,
delivery
just listen.
slip?
No, just listen. I would have thought that your drivers would have a document that gives them the names of clients and the addresses separate from the code, and that either they, if they didn't know the code to which address or client it related to, they would have a document somewhere where they could go and check. So from your point of view, you would just say, I need you to make a delivery to 1010. Then if they know what 1010 represented or which client it represented and the address, then they don't have to check. They say, okay, we'll pick the cash and we'll deliver it to 1010. If they didn't know, then they have a document where they could go and check that. That's what I would expect. But I see here you have got the address, the name of the client, the address of the client. Is the address there? Or no, you don't have the address, but you've got the name of the client, you've got the cell number of the client, and then you have got the code, and of course you've got the amounts. Yes, you can now explain.
So on my delivery slips, my drivers write this out, and I will let them know they need to take a certain amount to 1010, and so they would write the slip out beforehand, and then when they get to the client just signs for it. So yes, some clients might write their names out like this one, and some might just like sign for it. But this code was written by our drivers so that they can identify when they do the delivery that it's going to that certain client.
Okay.
So yeah, I didn't write out the slips. This was written out by my drivers, and that is how they would write it out to know what to do with the funds.
Okay.
Ms. Viljoen, there are some other delivery slips that you provided as an annexure to your affidavit to the FSB. You'll find those commencing at page 54.
Well, Ms. Hoffman.
Yes.
What happened to Ms. Viljoen's bundle has happened to mine. So, but for now I can continue. Maybe during the lunch break, you can swap.
I have to say, Chair, mine's holding on tight.
Yes.
Apologies, Chair. We'll give you a lever arch file, which may be preferable.
Should be a lever arch file. Yeah. Okay. All right.
If we just go to page 54, those, as I have it from your FSB affidavit, are some other delivery slips related to the particular investigation that they were conducting. Is that correct?
That's correct, Chair.
The copies here, Chair, at page 54 are very bad. You can barely make out what is said there. So we contacted Ms. Viljoen about it, and she has kindly made available to us the originals of those delivery slips, which I have in my hand at the moment. I do appreciate that being provided to us. What I just note here is these slips are slightly different to the previous ones. In fairness to you, there's a whole wad. So I'm just going to suggest that we hand a few to Ms. Viljoen and a few to yourself, Chair, so we can all be looking at a similar type. It's just about how these delivery slips change over time, if I may. We will then make copies of these for the purposes of the record, Chair, so that we can have the better copies in the bundle.
Yes.
The only point of distinction, it seems to me, Ms. Viljoen, and I'd be interested in your comment on it, is If we go back to the ones at page 24, just for comparison purposes, you'll see under delivery there, you seem to have a stamped number under the line Dell.
Okay, yes.
And then under the section for company stamp is written in hand 1010 on both of the delivery slips that appear on page 24. Is that correct?
That's correct.
If you look at the originals that we have circulated, there's nothing under company stamp. Is that correct?
That's correct.
But under Dell is written 1010.
That's
Is
correct.
there any significance to attach to that change?
No. You'll have to contact Minuteman and ask them why they changed it. Because these books were ordered from Minuteman. And if you look on the originals, there is a stamped number right next to seal number in red. So I can assume maybe they changed the way that they printed the books.
I understand. Thank you. That is helpful. And can I just ask, these delivery slips, which you still have the originals of, these didn't form part of what went to the liquidators, did they?
They do have copies of this, but my lawyer kept the originals. Yeah. But they do have copies of these.
So you made copies of some of the documents you handed to the liquidators and retained the originals. But in other cases, you didn't retain the originals.
That's correct. Yes.
What guided that choice?
Because they were busy investigating this, my lawyer kept this on file for us in case we needed the originals.
But you were happy to hand over all the rest in their original form.
Yes.
Thank you.
Your mic.
If we return then to this process, which we're about to complete, it's back at page 8 of your affidavit. You'll see if you pick it up at paragraph 5.1.4.11, you talk about what happens after the delivery slip has been signed. Can you take us through that?
Yes, it will be returned to me, and then I'll make sure that everything was delivered, and I would then normally file it.
And then in the last paragraph under that section of the affidavit, you talk about how you would reconcile all of this at the end of the month. How would that work?
I had a book where I wrote all the deliveries in. I would take the bank statements and I would take the SIPs and I would do a reconciliation for every client so that they can get a transaction sheet and an invoice at the end of the month.
And if we go to page 26, I understand that to be one example of the type of reconciliation you would do.
That's correct, yes.
And what we see there is at various dates over the month of May 2015, is that correct?
That's correct, yes.
You would have an amount deposited, an amount delivered, a service fee, excluding and including. What does that mean?
Excluding that, including that.
And then what does that last column read?
Including. And for some reason, I don't know why I put the column in there, but I never used it. But it's there.
So what you took out of the proceeds is reflected as amounts including and excluding VAT in the third and fourth columns. Is that correct?
That's correct, yes.
And you do that on a monthly basis, as I understand your affidavit?
That's correct, yes, Chair.
Just before we get into the detail of the 3 transactions that are pertinent for the investigation that the Commission has embarked upon, can I just check in relation to the delivery slips to Mr. Markidis that are the subject matter? I understand your evidence to be you don't have those delivery slips. Why was that?
We just had a robbery, or attempted robbery, I should say. One of my men were killed. The other one was in hospital. He had 7 ricochet bullets in his leg. And our vehicle, the one vehicle, was written off. And I can only speculate that the books were in that vehicle when it went in for recovery. That's the only thing I can think of why we wouldn't have had these slips.
Right. But you still managed to do a reconciliation, I assume?
I did, yes.
What did you rely on then?
My bank statement and again the book that I wrote in.
Thank you. I'd then like to move at page 8 of the affidavit to the section beginning paragraph 6, because this is where you start to deal with your business relationship with Mr. Markides.
That's correct.
And if we can pick it up at paragraph 6.2, you say all of the inquiries. What are those inquiries?
We're at the inquiry with the FSB, then the SME liquidators, and then of course this inquiry with the Hawks, everything we've been dealing with.
And you say all of the inquiries have related to transactions carried out for one person, namely George Markides, who was an existing client and who was a sole proprietor trading under one of two business names, being Dedrago or ITH.
That's correct, yes.
Can I just get clarity? Who was your client?
Dedrago, or George was my client.
George, the person.
Yes.
George, the person, was your client. And when you say there that it traded under one of two business...
That's Mr. Is it Markides?
Markides, that's correct,
Is that the correct pronunciation?
That's correct, yes.
Yes, okay.
So the client was Markides. Let me say in fairness to you, that's consistent with the checklist, because it's George Markides is the client, it's his ID number, it's his income tax number, and it's the address that you vetted for him, correct?
That's correct, yes.
And then you say he was a sole proprietor trading under one of two business names, being Dedrago or ITH. Do you see that?
I do, Chair.
I just would like to go to your FSB affidavit, if we may, at page 44.
44. Okay.
If we look at paragraph 5.20.2 on that page, you state there, in each of the transactions in question, I was contacted telephonically by an individual by the name of George Markides, whose business is known to me only as ITH, and which, to the best of my knowledge, is a sole proprietorship conducted by him.
Yes, Chair.
Is ITH the only trading name that you're aware of, or is it both Dedrago and ITH?
So what happened was they were known as Dedrago with Rustic Stone, and then when they moved over, they stayed Dedrago, and then eventually I saw in their signature they would refer to themselves as ITH.
What signature was that?
So if Lisa emailed me, then in her signature it would be, and if I phoned, they would answer ITH. So in my mind, I thought maybe a name change or whatnot, but
then it's not correct to say at paragraph 5.20.2 that the business is known to you only as ITH.
So when the FSB did this, I went to think about it all afterwards, and I started putting more things together. And they're known to me, that's why my statement to you says they're known to me as Dedrago and ITH.
And at the time that you did the FSB affidavit, they were known to you only as ITH. Is that correct?
Well, again, they were known as Dedrago, but I eventually called them ITH.
So it's not correct to say that they were only known to you as ITH?
It's not correct, yes.
Thank you.
I'm sorry. Once you knew about ITH, did you think that was a replacement of the other name, a change of name, or did you understand that both names referred to the same business?
Both names refer to the same business.
Okay.
Did you make inquiries to confirm that?
No, I didn't.
So you might have now been dealing with a different business, mightn't you?
Same person, might have been different business, yes. I did, however, ask who I can invoice, and they said to me, I must invoice Didrego.
So you must continue to invoice Didrego,
Yes,
despite the fact that you notice a name change or some other different business that you're dealing with.
yes,
And you were satisfied to continue to invoice in the old name, albeit that that's not what's appearing on the communications.
It was just, like I say, the email address. So it might have been her personal email address. I don't know, but they got to know me, or I got to know them also as ITH and not just Didrego.
But you made no inquiries as to the
No.
nature of that business.
No, the person stayed the same.
And that's why I have your evidence to be the client was Mr. Markidis, correct?
That's correct, yes.
Thank you. If we then go over to page 9 of the affidavit,
And that's her affidavit before the commission.
the commission, indeed, Chair. Apologies, there are 3, so it's useful to be a bit more specific.
Yeah.
It's the affidavit to the commission, which you'll find in Exhibit DD9 at page 9. You begin at paragraph 6.3 there, talking about your interactions with Mr. Markidis and the processes you followed for taking him on as a client and vetting him. It's that we do need to spend a bit of time on because it is Mr. Markidis's transactions or purported transactions in the amount of 9 million rand that this commission is concerned with. So if I may, you start at paragraph 6.3.1 and you say when Markidis, Mr. Markidis, indicated that he wished for his business, which I was led to believe was a trading house buying goods in South Africa and exporting them to the rest of Africa, to be moved from AMFS to Rustic Stone, our checklist was completed and I requested that he forwards a copy of his ID to us. Do you see that?
I do.
What does it mean when you say there, I was led to believe that his business was a trading house?
Well, with all the inquiries we've had so far, clearly that is not the case.
No, certainly, but who led you to believe that?
They did. George did.
So is that when you were making inquiries as to
Yes, I asked
his
him,
business?
what do you guys do as a business? And I was then led to believe that.
Why was his business relevant if he was your client?
I was just asking, general question, what do you guys do? Oh, how long have you been doing it? Normal conversation.
But you weren't then vetting the business. You were vetting Mr. Markidis, is that correct?
Yes,
So this was just part of the conversation.
that's right.
What does he do in the week?
That's
And
right. Yeah.
He told you he had a trading house buying goods in South Africa and exporting them. But it wasn't of concern to you to vet that business, was it?
Can I ask a question? How would I vet that?
Unfortunately,
Sorry but how would I vet that?
You must answer the questions, not ask the questions. If you
No.
know, you know. If you don't know, you don't know. Okay, what's the
Right.
answer?
Yes.
I think the answer is no.
Yes,
You
no
didn't-
is the answer, and
No
yes to chair.
You did not vet the business.
That's correct.
And if we go down, you say, I also confirm, this is at 6.3.2, that I sent AMFS's standard terms and conditions to him. Ms. Balloon, you mentioned that earlier in your testimony. In fairness, just explain to us what happened in relation to Mr. Markidis and those terms and conditions.
We never received it back.
But you continued to engage in business with him.
Yes.
And then at 6.3.3, you say that as I'd never been to Markidis's premises during my time at Rustic Stone, I conducted a site visit to 23 Whittaker's Way, Bedford View, and confirmed that the business was conducted there. Is that correct?
That's correct, yes.
Is that the only premises that you visited in relation to Mr. Markidis?
That's the only premises, yes.
And what business did you see being conducted there?
Well, it was offices. So they had the reception desk, and it was a normal office, boardroom.
Are you sure about that?
Yes, I am.
At that address?
At 23, yes, I am.
Do you know that your deliveries were not to 23 Whittaker's Way according to your invoices?
They had 2 addresses. I do know that. They had 2 premises. But I went to Whittaker, I vetted Whittaker, and that's where we did the deliveries.
But your invoices indicate that the deliveries were to another address?
As per their request.
So let me just get clear here. You know that they have 2 premises,
That's
but you
correct.
only vet one of them.
Because the delivery would have only gone to the one premises.
But none of your invoices reflect the 23 Whittaker's Way address as the delivery address.
No.
Then I don't understand why your invoice would reflect a delivery address which is not the address to which the deliveries were made.
As I said, they had the 2 addresses, and they were working out of Whittaker. It was their offices where they would always be present for the delivery, and that's where we went. That's where George was, and that's where we went.
No, but the point that's being made is the invoices reflect a different address, not the Whittaker address.
That was the address that they asked me to put on the invoicing.
Yes, and you didn't vet that address.
It was also the same address that came from Rustic Stone, so it all stayed the same.
No. The question is, did you vet that address?
I did not go to that address, no.
And why not?
Because, as I said, my deliveries were to go to Bedford View as per their request.
You said earlier on that when your driver had delivered the cash, they would come back and give you, I think, a note.
Yes.
Which would be proof that the delivery of the cash had taken place. Is that right?
That's correct, yes.
And that note, whatever you call it, would have the address at which the delivery took place?
So the Drago's deliveries always went to Whittaker because that's where he sat every day. That's where his offices were.
So you are saying, are you saying that there were no deliveries made by your drivers to Mr. Marquez at any address other than the Whittaker address?
It would have been the Whittaker address, yes.
Yes. But you were not doing the deliveries yourself, were you?
No.
So, therefore, you can't know that for sure, can you?
No. It would have gone to where George is.
No. If you didn't do the deliveries or you were not there when the deliveries were effected at the address, you can't know that. You would have to depend on reports from somebody, isn't it?
No, I would tell them where to go.
Yes, but they could
So
decide
they would
not
go
to listen
there.
to you.
No. No, they went where they were supposed to go.
No. You don't know for sure whether they went there if you were not there when they delivered.
I was not there.
Yes, therefore you can't know. All you can say is, my drivers told me that they went to the address to which I said they should go, and I trusted that they were telling the truth.
That's
But
correct.
whether or not, in fact, they were telling the truth, I don't know.
We can say it like that, yes, Chair.
It has to be like that.
Yes, Chair.
Okay. Ms. Hofmeyer.
Let's go to your invoices for this client.
Page?
We'll find one of them at page 25. This is an invoice arising from your business relationship with Mr. Marquez. Is that correct?
That's correct.
Am I correct in saying that this page makes no reference to Mr. Markides anywhere.
That's correct.
It refers to what seems to be an entity called Dedrego, correct?
That's correct.
Not a business that you ever vetted.
That's correct. But George is Dedrego, though.
No, but Ms. Viljoen, I spent some time being very clear about who your client was.
Yes.
And who you were concerned to vet.
Okay.
And that is Mr. Markides, as I have your evidence.
That's correct.
His
yes.
income tax number, his cell phone, his address.
That's correct.
Right. And this invoice indicates that you are delivering for Dedrego to 56 Watt Street, correct? There is no reference on this to 23 Whitaker's Way, correct?
That's correct.
Why would you allow invoices to be prepared for a customer that incorrectly reflected who the customer was and where the proceeds in millions of rands were being delivered?
As I said, Dedrego is at Watt, but also they've got premises in Whitaker. And Mr. Markides was always at Whitaker.
Yes. So why do the invoices for Mr. Markides, who was your client, not reflect that as the
Because I
delivery?
think that Dedrego is actually registered at this address.
Ms. Viljoen, the difficulty that invoices that reflect the wrong facts create is that in a situation where you are an accountable institution under FICA, precisely what you do to vet your clients is extremely important. Do you accept that?
I do.
And particularly because businesses that move R500 million a month need to be on the lookout for, amongst other things, whether they are involved in facilitating money laundering, correct?
Correct.
Do you then accept that in a business where the relationship is with a natural person and an address of that natural person has been vetted, but invoices are prepared in relation to the trading name through which he's conducting business and another delivery address, you are creating a false impression of the nature of the business relationship?
I can see how it can look like that, yes.
Thank you. If we
But I'm sorry. When your driver came back from making a delivery, they would give you a document which showed, or which was supposed to show, where the delivery took place and who the client was. Is that right?
That's correct.
What did you call that document?
Delivery notes.
Delivery note, yeah, okay, all right. I just wanted to make sure we are on the same page. Would you examine each delivery note when each driver came back to see whether what was written there was in accordance with your expectation in terms of whether the money was delivered to the right client and at the right address?
As we said earlier, the address is not on the delivery slip for security purposes, Chair. So I would check the amount, and I would then, of course, confirm that the client received the funds. But the actual address is not on the delivery note.
Yes, but was there anything, or how did you ascertain where the delivery took place? In other words, whether it took place at the correct address. How did you ascertain that? How did you find out that?
Well, if it wasn't at the right address, then the client wouldn't have signed for it.
Sorry?
If it wasn't the right address, then the client wouldn't have signed for it. And we only went to where the client said, "This is our address. This is where you please must deliver the funds."
Well, the client could have given you the Whitaker address, but could have arranged, couldn't he, that the delivery be effected at a different address?
It would have been their address.
Yes.
Not at a
their
different
address,
place. Yeah.
but a different address from the one recorded in your books.
So it could have gone to what street? Is that what you're saying, Jim?
No, I'm saying in terms of the address of, for example, Mr. Markides, your records reflected that his address, as I understand the position, was the one for Whittaker Way. Is that right?
That's correct.
That's the only address that you had in your records for him, or was there another address?
I have two addresses
You had
for
two
him.
addresses.
Yes.
Now, your instruction to the drivers was
Yes,
it
Chair.
that they should deliver at any one of the two addresses, or was your instruction that they should deliver at a particular address, namely the Whittaker address?
I have to say I could have told them to go to both addresses, but my memory of maybe our later deliveries was definitely we always went to Whittaker. But yes, in the earlier days, they might have gone there.
But,
But as I said, my memory with our later 2017, 2016 is we normally went to Whittaker.
Yes. Was there any particular importance as far as you were concerned of the address to which the cash was delivered?
Just where
In
the
oth-
person would be to sign for it.
In other words, if cash was delivered into an address other than the one that you wanted them to deliver cash to, would that have been something quite important to you, or was the position that as long as the cash was given to the client, it didn't matter in which address it was delivered?
How to explain? As long as the client was there at the address that they supplied us with.
If the client was at an address that had not been supplied to you, were your drivers permitted to deliver?
No. They had to go to the offices.
Yes. Okay.
Thank you, Chair. Ms. Viljoen, when you went to Whittaker's Way, were they operating from a house?
Yes, it looked like a house, which they converted into offices.
So, because Whittaker's Way is a residential street.
That's correct, yes.
Yes.
They converted it all into offices.
But at that stage, your client was Mr. Markides, correct?
That's
So
correct, yes.
it was relevant to vet the address he gave you, correct?
That's correct, yes.
And as I have your evidence previously, you made no inquiries whatever about the source of the funds that Mr. Markides was depositing into your account.
That's correct, yes.
We'll go
Except
to...
I vetted him, I FICA'd him, and of course I confirmed with his PA that it is their funds.
Well, Ms. Viljoen, I FICA'd him is something that I am going to have some difficulty with. What does that mean?
I got all the necessary documents from him. Sorry, my bundle unraveled again.
That's fine.
Well, Ms. Hofmeyer did tell you she thought it would happen again, and
And there was a promise, I think, that it wouldn't, but I certainly won't hold that against Ms.
she
Viljoen.
warned you about that.
Indeed.
Is it more convenient to change now, to give her
Let's
the
twist
right file
this
now?
now.
I think we should possibly do that, Chair.
Yeah, let's
Just
do
for
that.
convenience.
Yeah.
Right?
Let's do that. No, let's do that. Forget about that one, Ms. Viljoen. You'll be given another one, so we won't have this again.
Ms. Viljoen, just to be clear, we've used another file we had on hand. Please don't look at the spine because it relates to another witness, but it's just for convenience purposes that we'll give it to you in this
I've
form.
now twisted it into little swirly, so I'm thinking maybe it might hold.
Well,
Yeah.
let's put the other one there in case.
Thank you.
I said I wanted to pick up on your statement that you FICA'd the client because we'll go to the sections shortly, but amongst the legal obligations you had as an accountable institution was to establish the source of funds of any of your clients, and I have your evidence to be you did not do so.
except for calling them and confirming with them.
Ms. Viljoen, calling them and confirming with them that a payment has been made is different to establishing from them where they source the funds that they are going to transact with you on. Do you see that difference?
I see, yes.
And you'd made no inquiries as to the source of the millions of rands that Mr. Markides was asking you to deliver in cash in your business relationship?
My understanding was it comes from them.
Who is them?
Mr. Markides, his entities. It comes from him, his company. It comes from them. How do I explain that?
No, you've explained it, Ms. Viljoen, but there is a difficulty with that answer because your onerous obligations under FICA require you to know where funds are coming from when you transact with a business as an accountable institution. Do you accept that?
Sorry, I was under the impression, or my impression was, that if it's an electronic transfer, that it's the bank's responsibility to source where the funds come from. Where if it was cash, then it was my responsibility to see where the funds were coming from. But if I am wrong in my understanding, then I do apologize. But that was my understanding.
We'll come to the legal obligations in due course. For present purposes, you didn't check funds, you understood Mr. Markides was your client, and you did not vet his businesses, correct?
Correct.
And in terms of the amounts associated with Mr. Markides, you indicate in your affidavit that they comprise less than 1% of the business of AMFS. Is that correct?
That's correct, yes.
But that's still millions of rands, is it not?
Yes.
I did a quick tally of the delivery slips that were relevant to the FSB affidavit. It seemed to be in the order of in excess of 20 million. Is that a fair computation on my part?
I think it was a bit more.
Possibly 30.
I'm not sure, but it was a bit more, yes.
And then at least 9 million in relation to the transactions that we're interested in. Thank you.
Right.
And if we...
Just remember to...
Oh, yes.
Even
The answer there was
rather
yes.
nodding.
No, I said correct. Maybe I didn't say it loud enough.
No, I think you just nodded.
Okay.
Okay.
Let us then please move to your interactions with the Hawks, and you'll find those in the affidavit to the Commission in Exhibit DD9 at page 11.
DD9.
That's the file that you're in.
Yeah.
And it's at page 11. You begin at paragraph 6.4.3.1 there. And as I read it, you state, in March 2018, I was contacted by a certain Captain Mogosi, who stated that she was from the Hawks and wished to interview me as a witness relating to a case involving a company called Co-ordinator. Do you see that? Please say yes.
Yes,
indeed. Thank
sorry.
you. And the next paragraph, you say, as I did not know this company, I asked her to explain, and it became clear to me that this had once again to do with Markides, Mr. Markides. Is that correct?
That's correct.
Ms. Viljoen, you did know, though, in March 2018 about Co-ordinator, did you not?
As I said earlier, I completely forgot about Mr. Judil when I met him in the December. I remembered when you sent me this statement a week ago. Oh, yes, okay.
Well, when Mr. Judil engaged you in December 2018, had the other issues around Mr. Markides arisen yet?
No, not yet.
So you had an interaction with a private investigator for whom you prepared an affidavit detailing and providing all your records of delivery slips with Mr. Markides and its association with Co-ordinator. But when you were contacted in March 2018, you'd forgotten the reference to Co-ordinator. Is that your evidence?
Yes, that's correct.
Thank you. And then you go on in that on that page to explain the extent of your interactions with the Hawks and steps that you took in relation to the particular transactions that they were interested in. Can you tell us what those were?
what steps I took.
Yes.
I just gave them all the details. We met at a restaurant, and we weren't there long. I opened my water, and I don't even think I finished my water. And I just explained the business. I gave them all the invoices, I think, and some slips. And they said they'll contact us because I might need to be a witness. But it wasn't a very long interaction.
Ms. Viljoen, as I understand your evidence, there's something that you do between the call from Captain Mogosi and then meeting up with her and her colleague at the restaurant in Bedford View, and that involves an interaction with Ms. Lisa Zogby. Is that correct?
That's correct, yes.
Who is Lisa Zogby?
She is George Markides' PA, personal assistant.
So what did you do in relation to her?
When I couldn't find our delivery receipts, I contacted her and asked her maybe for her copy. And then she sent me a brown envelope. She said it's fine, she'll send proof that the funds were delivered. And she sent me a brown envelope with receipts in there.
Okay, let's just go back in the evidence. I understand you didn't have copies of the delivery slips yourself because of that heist.
Yes.
Is that your evidence?
Yes.
And then when you got contacted by Captain Mogosi, you then took steps to try and get the client's countercopy or the other
Yes.
copy. Is that correct?
That's correct.
And then you made contact with Ms. Zogby for that purpose.
That's correct.
And just tell us precisely what happened then.
She sent me a brown envelope.
Did she send it or did you collect it?
My old driver went to collect it from her premises, and he dropped it off.
And then what happened with those slips?
I gave it over to the Hawks.
At that meeting?
At that meeting, yes.
Okay, I just want to go to the question of your retention of the delivery notes. And for that purpose, I'd like to go to your affidavit of December 2017, which you find commencing at page 91 of the Exhibit DD9. And if you go down at page 92, it's the second page of that affidavit to paragraph 7, you say there, according to my delivery notes, the funds were delivered as follows, and then you detail what happened on the 8th of May and what happened on the 16th of September. I'm just not sure I understand what delivery notes you were looking at there.
As I said earlier, I didn't write this, and I did not have delivery notes. So I think what it should say is maybe my transaction sheets, because I did not have any slips.
Ms. Viljoen, you did give evidence that you didn't write it, but you did give evidence that you read it before you signed it, correct?
Yeah.
So this is an error in its recordal.
Yes.
You didn't have delivery notes.
I did not have delivery notes.
So you engage Ms. Zogby because you want to see if she has copies?
Yes, maybe she might have copies, and I just didn't get it, or I can't understand why I didn't have the copies. That's why I said maybe we did not write anything out. But yeah, I contacted her to see maybe if she's got receipts.
And did you satisfy yourself as to the delivery notes and their authenticity before you handed them over to the Hawks?
No. And when we had this discussion, I went and I thought about it. My driver delivered them, and I went to put them in my car, and then I went to pick up my daughter. And I never checked them up until when the Hawks opened up the brown envelope, and it had my name on it. And when they opened it, that was the first time I saw it.
What period of time lapsed between you collecting them and you meeting with
It's probably a day or two.
And can we go to those documents that you say were in the brown envelope?
Yes.
You'll find them at page 64. Are those, and they comprise 3 pages, as I have your evidence. It's 64, 65, and 66, correct?
That's correct, Chair.
Are these accurate copies of what you saw in the brown envelope?
That's correct, yes, Chair.
And are these your delivery notes?
They are not, no, Chair.
Do you have any other knowledge about these documents?
Just when I gave them to the Hawks, I said to them, these are not my delivery slips.
You say in your affidavit that
I'm
you think...
I'm sorry, Mr. Mayor, let me just get this. When you spoke to Mr. Makida's PA to ask for their copies of delivery notes, is the position that what you were asking for was copies of what your drivers would have brought back to you after they had delivered cash to them?
Yes, that's correct, Chair.
But what they gave you, what she gave you, was delivery notes or was something different?
That's correct, yes, Chair.
Okay.
As I have your evidence, Ms. Viljoen, you speculate at paragraph, if we return in your affidavit to page 12, you say at paragraph 6.4.3.13 on that page, I confirm having now considered these slips and once again reiterate that the slips are not my documents and I'm unable to comment on same, further than to state that I believe they may well be evidence of the on-delivery of funds once AMFS had delivered same. Do you see that?
I do see that.
What is the basis for your comment there?
Can you elaborate, please?
I'm asking why you said what you said in this paragraph. Why do you surmise that they have to do with on-delivery?
Well, that is clearly what has been happening with Mr. Malkidi's cases. If I just look at the SME case, so I can make that assumption that the funds actually never went for his business and it went on to someone else.
Were those facts that were established in the SME Bank
That's
of
correct.
Namibia case?
Yes, that's correct.
So he transacted with you, but then he made those funds available to third parties.
That's correct, Chase.
So it's on that basis that you regard these as evidence of the onward
That's correct, Chase.
movement of the cash.
Yes.
If we then move over to page 13, we are finally, Chair, going to arrive at the transactions that are relevant to the investigation. The background,
Yes.
I submit, has been important, though, to
No, it was
understand
important,
the manner
yeah.
in which the business was operating. As I have it, Ms. Viljoen, there were 3 transactions related to matters involving Coroneka, a closed company. Is that correct?
That's correct, Chase.
I'd like to suggest that we just go to the bank statements to pick up where those payments were received by AMFS. The first of those you'll find at page 70. Is this your CC's bank statement?
Yes, it is.
And you were banking at that point with Nedbank, correct?
That's correct, Chair.
If you go to the 4th line on that page, you'll see a date 08/05/2015, and then you'll see a next column that is headed description or narrative. Do you see that?
Yes, Chair.
What is reflected as the description or narrative for that?
Coroneka and the date.
Coroneka.
Coroneka and the date.
Ms. Viljoen, just wait until she has finished the question and then answer.
Okay, Chair.
Okay.
Under description or narrative, please read out to us what is reflected there.
Coroneka and the date.
Just to get that 06/05/2015, correct?
That's correct.
And then if we move across to credits, what is the amount that comes into your bank account?
The 2 million.
Okay, so let's stop there. You've told us a lot about how you would check payments that came in to verify who was sending you the amounts. So when Coroneka and a date 2 days prior to this date came into your account, that didn't cause you concern that it might have been from a source other than Mr.
No.
Markidis?
No.
Why not?
Like I said, I confirmed with them that it is their funds, and my assumption is they're using Coroneka for their own referencing purposes.
Right. And then the second one on that page, you'll find...
I'm sorry. That last answer. Why would they use a reference that would mean nothing to you when they deposit amounts into your account? Isn't the purpose of a reference so that when you see the amounts, you know what it's for and where it's coming from?
Chair, I had this discussion with Ms. Hofmeyer when we met the first time, and you'll see on my second bank statement, there's clients using AMFS as their reference, and so I had to call clients and confirm that that was their money. So the reference means nothing to me, but it is important for the clients, of course. So I did not find that to be funny.
Yes, but I would have thought that a reference was important to you.
No, the referencing is not important to me.
Let me tell you why I would think it was important. Because then you wouldn't have to phone the client each time there was money put into the account.
Chair?
If you had a reference with a client to say, in your dealings with me, your reference when you deposit any money will have to be this. And then if you saw that there was money under that reference, then you wouldn't have to phone the client. Do you agree?
I do agree, yes.
You didn't have that arrangement with your clients?
I did not have that arrangement, though, no.
And you did tell us that in a morning you could get up to 100 requests.
Near the end, yes.
And that the fact that you didn't have that arrangement must have meant you had to make many calls.
No, when it was late in the business, when I got all those phone calls, they did start using references identifying themselves better. But when it all started, I did not have that agreement or anything like that with the client.
Yeah.
If we look on that page 70 for the second relevant transaction for our purposes, Ms. Viljoen and Chair, you'll find it just beyond midway down that page. There's another entry on the 11th of May 2015 that reads Coroneka. Do you see that, Ms. Viljoen?
I do.
And what was the amount deposited on the 11th
2
of
million.
May? And then if we go over to page 74, apologies, not 74, 84, you'll see again, just below halfway down that page, there's an entry for the date 16 September, and the description is BK. Do you see that?
I do, Chair.
Do you confirm, what is the amount of that?
Let me try
Apologies.
And see if I
it's very
can
difficult
see.
to find it. Chair, if you...
will I find the reference to BK on the second column? which
Yes,
comes
in the
after
description
date?
column. Chair, if you track the description column down just below
Oh,
halfway,
yes.
you'll see
Yes,
a
okay.
BK.
Yeah, I see it.
And the amount there, Ms. Viljoen?
It's 5 million.
5 million. And these three amounts reflecting Coroneka on the 8th of May, Coroneka on the 11th of May, and BK on the 16th of September, have you satisfied yourself all relate to payments from Coroneka
That's correct, yes.
and not from Mr. Markidis?
Yes.
And it's September 2015, 2016,
All 2015, Chair.
All 2015, okay.
Chair, we're going to look in a moment in Ms. Viljoen's evidence at the flow of funds diagram. because those dates become relevant when we look back at the evidence that's been given previously about when precisely funds came into Coronacre and when this total of 9 million came out. But we'll get to that at an appropriate point, with your leave. And Ms. Viljoen, I'd then like to take you, if we may, to page 14, the next page of your affidavit.
Okay.
And pick it up at 7.3.7, because here you pick up the point about yourself not being in possession of the delivery slips. We're at page 14, Chair.
Sorry, what page?
Page 14.
Okay.
And we are at paragraph 7.3.7.
Thank you.
You say there, although I'm not in possession of the delivery slips relating to the 3 deliveries, I confirm that the funds were delivered to Marquides at his place of business. And Lisa Zogby confirmed this by sending their version of the receipts. Do you see that, Ms. Viljoen?
I do.
When you say at his place of business there, what place do you mean?
Whittaker.
You know that for certain?
We did most deliveries to... Actually, no. I don't ever recall us doing deliveries to the Springs address. So I want to say yes. We did the deliveries all to Whittaker.
But following on from the chair's line of questioning earlier, you don't know that as a fact, do you?
I don't know it as a fact, but my instructions to my drivers were Whittaker.
Despite what was reflected on the invoices?
Yes.
Ms. Viljoen, I then want to move to paragraphs 7.3.9 and 7.3.10 on that page, because you make some, what I want to suggest are concluding remarks there, after your affidavit has detailed the facts of your engagements with Mr. Marquides and your processes. At paragraph 7.3.9, you state, I wish to record that I took all steps necessary to establish Marquides' identity and confirmed same by obtaining a copy of his identity document. I obtained his income tax number and personally inspected his business premises. And then the next paragraph, I never received any cash at all from Marquides, and I further confirmed that the transactions in question were run-of-the-mill for cash in transit business and did not seem suspicious at all. Do you stand by those statements?
I do, yes.
Then I've kept promising in the course of your evidence that we would finally go to FICA and look at the various obligations that you had as an accountable institution. Chair, with your leave, I'd like to go there.
Yes, let's do that.
You'll find the relevant provisions in the legislation bundle under tab 5, which contains the Financial Intelligence Center Act, 38 of 2001. And where I'd like to suggest we start is at page 122 of within that act. Ms. Viljoen, we've already established in your evidence the importance placed on...
I'm sorry, Ms. Hoffman, did you say page 122?
122 in the top right pagination. Do you have that, Chair?
Yes, thank you.
We've already covered in your evidence the responsibility that accountable institutions have to take steps to guard against money laundering. You accept that?
I do.
And you had taken legal advice that you were an accountable institution under FICA in the form of a money remitter, correct?
Correct.
So we start with what the FICA requirements are on that page at section 21. You have to, among other things, I'm going to summarize just for the purposes of the efficiency of the evidence. What section 21 is concerned with is your need to establish and verify the identity of the client. That's under 21(1)(a). Do you see that?
I see that, yes.
And then if you go down to 21(A), you're also required to understand and obtain information on the business relationship. You see that? And what you have there is the following. When an accountable institution engages with a prospective client to establish a business relationship, as contemplated in Section 21, the institution must, in addition to the steps required under 21, and in accordance with its risk management compliance program, obtain information to reasonably enable the accountable institution to determine whether future transactions that will be performed in the course of the business relationship concerned are consistent with the institution's knowledge of that prospective client, including information describing A, the nature of the business relationship concerned, B, the intended purpose of the business relationship concerned, and C, the source of the funds which the prospective client expects to use in concluding transactions in the course of the business relationship concerned. Do you see that?
I do.
And I have it as your prior evidence that you did not at any point establish the source of funds as you were required to do under Section 21, capital AC. Is that correct?
To me, establishing where the funds came from was to contact and confirm with the client that it is their funds.
The source of funds that the prospective client expects to use in concluding the transaction. Let's break it down in fairness.
Okay.
Your client is transacting with you, is it not, by
That's
depositing an amount in your account?
Yes, that's correct.
So what this section, if we read that section in plain terms, it's saying you must establish where the source of funds for that transaction with you is coming from. Do you see that?
Again, I would read it as they are the source, and I confirmed they are the source from them.
Did you receive legal advice to that effect?
Not that I can recall.
Would you have read this yourself, the actual act yourself?
I can't remember, Chair.
In other words, where would you have gained information from?
I did ask
Hang
my
on,
attorney.
Ms. Viljoen. Just
Sorry,
learn to wait until the question is completed.
Sorry, Chair.
Okay. Where would you have got the information from as to what your obligations were under FICA?
My attorney sent it to me, and I probably would have read it on all the information sent to me.
He would have, did he send to you the whole act? Did he send to you relevant sections of the act? Did he send to you a memo or a note or a letter explaining what the obligations were?
I cannot remember in which format it was sent.
Yes.
I can't remember.
Okay, but do you have a recollection that you did read the act, or you don't have that recollection? The act, when I say the act, not necessarily that you read the whole act, but at least you read what you considered was necessary to establish your
I do
obligations.
remember reading some, yes.
Okay. And you did understand that the act required you to establish the source of the funds? Or what was your
My
understanding?
understanding was I can confirm with the client that it is their funds, and that would of course be then the source of the funds.
That was your understanding?
Yes, Chair.
Not that you were to ask the client, where did you get the funds from?
No, Chair.
Okay, all right.
Just to go back to the language of 21 capital AC, you'll see that it says that what you need to establish is the source of the funds which that prospective client expects to use in concluding transactions in the course of the business relationship. So source of funds are where they got, what they are going to use in transacting with you. Do you see that reading?
I see that now, yes.
You didn't see that reading at any point previously?
I don't recall doing that, no.
If we go over the page to page 123, the next relevant obligation is at 21C, right at the bottom of the page. It's a requirement to do ongoing due diligence. Were you aware of that obligation?
No, Chair.
And you'll see we've had this reference before. There's a constant reference in this section to a risk management and compliance program that each accountable institution has to develop. Had you developed one of those?
Can you repeat that, please?
If you look at section 21, capital C,
Yes.
it begins, an accountable institution must, in accordance with its risk management and compliance program, and then it goes on to talk about the various steps you take to do a due diligence. What I'm interested in is we've had that reference to the risk management and compliance program in the previous section we were looking at. And I'm just asking, did you develop a risk management and compliance program in your business?
I did not, no.
Are you aware that that's another requirement of accountable institutions
No.
under FICA? Please give the answer now.
No.
Thank you. If we speak at the same time, the record can't pick it up.
Pick it up, okay.
And then 21E is fairly important for the conducting of your business, Ms. Viljoen, because what 21E provides is that if an accountable institution is unable to do certain things, and I'll go into it in detail, it may not establish a business relationship with any client. And let's look at what you have to have in terms of this section before you can conduct business. You have to establish and verify the identity of the client or other relevant person. That's A. Under B, you have to obtain the information contemplated in 21 capital A. You'll recall that's the section dealing with source of funds. And you have to conduct an ongoing due diligence as contemplated in 21 capital C, which we've just been looking at. And if you fail to do any of those three things, under Roman numeral 1, you may not establish a business relationship or conclude a single transaction with a client. Do you see that?
I see that.
Ms. Viljoen, your evidence has been that you did not take those steps, correct?
Correct.
So this section means you were prohibited from establishing any business relationship or concluding any transaction with any of the clients in respect of whom you did not take those steps. Do you see that?
I see that, yes.
Thank you. If we go over the page to section 125, those are the sections there dealing with the duty to keep records. I indicated to you earlier in the evidence that we'd go back to those sections. In summary form, and I'm happy to go to the actual text if you want to, but what sections 22 and 22A indicate is that you must keep records of the due diligences that are done, and you must also keep transaction records. Were you aware of that obligation?
No, I was not.
And then at section 23, it makes clear that those records have to be kept for a period of at least 5 years under sub A. Do you see that?
I do.
I take it you were not aware of that obligation either.
As I said earlier, no.
And then, Ms. Viljoen, if we go over to page 129. Chair, I see we are at 1 o'clock. There are one or two aspects just to complete on FICA.
Yes, let's
With
do
your leave, I
that.
suggest we do that
Yeah,
and then take the break.
Let's do them.
So at page 129, there's a section dealing with suspicious and unusual transactions. That's section 29. Do you see that?
I see that, yes.
Chair, this section is one of the sections of FICA that actually is not confined to accountable institutions. Most of the sections of the Act place obligations on accountable institutions, and that's why we've been engaging with Ms. Viljoen, because she understood herself to be an accountable institution. Section 29 is actually much broader. It applies to any person who carries on a business or is in charge of or manages a business, or who is employed by a business and who knows or ought reasonably to have known or suspected certain things. I only preface the question with that so that we understand this is an obligation that accountable institutions and others have under FICA. And what you're required to do, Ms. Viljoen, as any person who carries on a business, is to make a report to the Financial Intelligence Center if in the course of your business you come across what are called suspicious and unusual transactions. Were you aware of this provision of the Act and the obligations it placed on you?
I was, yes.
But I had your evidence earlier that you didn't look at the guidance notes ever that were published by FICA. Is that right?
That's right, yes.
Did you ever make a suspicious or unusual transaction report to the FIC in the course of your business?
No,
But you were aware of the obligation to do so?
yes.
You'll see that one of the examples of a suspicious or unusual transaction, which you're required to report on under B, is a transaction or series of transactions to which the business is a party, Roman 1, facilitated or is likely to facilitate the transfer of the proceeds of unlawful activities or property which is connected to an offence relating to the financing of terrorist or related activities. And Roman B, it's a transaction that has no apparent business or lawful purpose. Do you see that?
I see it, yes.
And then under C there, one of the other suspicious or unusual transactions are transactions where the business has been used or is about to be used in any way for money laundering purposes. Do you see that?
I see that, yes.
So if you had been alerted to the fact that your business was being used for any of these purposes, you did know that you had an obligation to report it, correct?
That's correct, yes.
Chair, just to conclude this point, the guidance note which is of relevance is the one that appears at 159.1 of this bundle. And the relevant page you'll find at 159.14, 159.14. And you'll see on that page, Ms. Viljoen, there's a heading, Unusual Business. Do you see that?
I see that, yes.
Just to give you the benefit of this part of the notice, what the FIC is doing in this guidance note is it's trying to provide financial, accountable institutions and others with guidance as to what they should be on the lookout for suspicious and unusual transactions. Okay. And you'll see under that heading, Unusual Business, there's a list, bulleted, of the types of unusual businesses that you should be on the lookout for. And it's the first one that I'm interested in, deposits of funds with a request for their immediate transfer elsewhere. Ms. Viljoen, that's a description of your business, isn't it?
Yes.
Thank you. Chair, there will be a few questions to follow up on after the break. I don't imagine that they will take long, but if it's convenient, we can take the lunch break now.
Okay, we'll take the lunch break and we'll resume at 2:05. We adjourn.